especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Oh, for Trump's sake. Mihi Anglican praise, verbis Latino. I didn't ask you to interrupt.
Is that correct?
Literally not true.
Good morning, good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Still training on all the equipment on my desk. Oh, man. I apologize. I guess I needed more time to recover from the weekend than I thought. But I did get a couple things done yesterday, and I'll have to get you pictures now of the newly installed sink. Plumbed, installed, caulked, beautiful sink, cabinet, everything else. It's so good, so good. So that matches we've got the toilet first. Now you can wash your hands afterwards, which is a big step up in the civilized world of being able to wash your hands. So wow, I ditched you a little bit. Yesterday fell apart. Yesterday fell apart. Like everything we're watching just went down the tubes. Like feeds were lost. It's I don't know what happened. It was like it was not meant to be in the afternoon. I do apologize for that. But let's see. I do notice that Cherry Smith's having a birthday today, so we have at least one person to sing to this morning. Welcome. Let's see. Oh look, Sherry Smith and Stacy Stevens, both on the birthday list, and both have first and last names. Let's start with S.
Shame on you, sir.
Shame also starts with S, but that has nothing to do with that. Alliteration. We've got lots of S's. It means we're going to sing in the happy birthday song, and that's okay. That's all right. Welcome, one and all. Good to have you all here. Greeners, if we can put you on the screen there. Greeners, congratulations.
I'm not going to argue about.
I don't know how you do it, Greeners, and honestly, most people don't either, although they have questions. But you have, in fact, won the internet once again this morning, being first in chat. Congratulations! It wasn't even close. You were here. It was done. Yeah, that's what we're waiting for. That's one of the. Thank you, by the way, Keshet, sending me messages as we're speaking right now. My wife is bringing them in. One of the cases we're looking at that was in jury selection yesterday is the non-political case. It just happens to be a senator who's on trial. So we're going to look at that, and hopefully we should get somewhere with that one today. But fingers crossed that everything works well. Everyone's been taking plea deals. Okay, what's with the plea deal thing? Brian Koberger, you look what you started. Kelly H. gifted a membership. It's so hot. There we go. That's better. That's the sound you make for a cat. You go. You guys, you see in the back of the cars with all the bumper stickers, and it says, "Tell your cat I said." Pss, 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 pss. Yeah, that's the sound you make into the mic to see if it's picking up too much. Because if it's like, pss, 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 then you know it's too much. Anyway, I haven't had any Mountain Dew this morning. Kelly, congratulations, or thank you, my friend, for gifting a membership to kick things off, and also coming in with a super chat. So glad you're back. Don't ding-dong ditch us without warning again, please. Thank you. Okay, Kelly. Next time there will be warning. No, I hear you. It was rough. Sharkey, oh my goodness, yes. Raul Valle has been charged again, this time with all the reckless lesser includeds. All the reckless lesser includeds from the previous trial he's been charged with. Much lower penalty on this round. But they are proceeding with this new trial, or at least they appear to be right now. And I think what really inspired them to do it is when the foreman of the jury, the deliberating jury, revealed that they were hung 11-1 in favor of guilt on the reckless, and there was one holdout. But just on the reckless, they were all not guilty on the uppers, and they were only, in favor of guilt on the reckless. So, wow. So that's going to be happening for sure with that sort of fact in your back pocket. Not that it's past performance is not indicative of a future success or something like that, whatever they say in the stock market. That doesn't mean that the next jury will come in and think the same, but there's a good indication they might. So that's going to be another trial we might see one more time. If we do, it's probably going to be very similar. I think the state will try it very similarly to how they did the first time, only instead of trying to talk about how he planned the murder and showed up, they just have to show he was reckless, and it's a lower bar. It's a much lower bar. Focusing all your attention on that lower bar, I think Raul may have his hands full as lawyer as well. All right. The trial in Colorado, Dennis poisoned his wife. Yes, that one is unfortunately not going to be live streamed other than the openings and the closings. The judge has sealed that one up tight, and that's the only time we're getting a camera, is my understanding, even though I'm on the approved list for media for that trial out of that courtroom ever since Letitia Stout. I guess they just added me to the list in Colorado, which is great. Not one we're going to be able to get because the judge is not letting cameras film everything. Let's see. What else do we have? We have Kim R. Kim, we wandered around YouTube aimlessly again. Sorry. I am so sorry. Yeah, just to give you a clue, as soon as I logged off, I think the mods were talking. I'm not going to say who said what, but they know me really well. They were talking in mod chat, and I was busy doing some things. And one of them asked, "So are we coming back?" And the other one said, "Probably not." And I'm like, even though I said I was, you're right. You're quite right. It just, everything went downhill, and I could not. As I notice how much dust is on my desk. Look at this. That's disgusting. Listen, this is my goat. I've opened pop cans that were louder than that. There we go. That one still works. What kind of batteries these take? Small ones. All right. Sounds like my cleaning spray bottle. The goat is out of gas. Virginia Little, you left us hanging. Rude. Virginia, I'm so sorry. I'm back. I need a new battery. I do. Batteries are probably the same price as the new goat, but this is the original goat. So. Takes 2 batteries. I bought a bunch from Amazon, and it's really cheap. Camila, I'll have to look. Do you know the size of the battery? Also takes good eyesight and a tiny screwdriver, apparently. So we'll figure that out. I was hoping to jump into Judge Middleton. Well, let's see. It depends when this one's going to start. Hold tight. Oh yeah, birthdays. Here we go. Kenda D. Esme. Is it Esme? Esme? Is that what it is, or Esme? Emily, Sherry Smith, Stacy Stevens, and Ashley have birthdays today. I'm curious. Is it Esme? I don't know. I'm just going to choose one. Here we go. It's going to be Esme. Esme it is. All right, we're going to sing to Kenda D, Esme, Emily, Sherry Smith, and Stacy Stevens, and Ashley. Oh, the "and" there is throwing me off, but I'll fix it. All right, when I say we, this is not me. I've never in my life have I sung a solo on the happy birthday song. Never. We've always, everyone who hears joins in, as you will. Wherever you are, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, warm up with me if you will. La 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 la. There we go. Esme. Okay, Esme. Got it, Melissa. Happy birthday to you. Happy birthday to you. Happy birthday, Kennedy, Esme, Emily, Sherry Smith, Stacey Stevens, and Ashley. Happy birthday to you. Sherry Smith, Stacey Stevens, and Ashley. Ooh, that was a lot of S's in there to try to squeeze together. But I think we barely did it. Kennedy, Esme, Emily, Sherry Smith, Stacey Stevens, and Ashley, happy birthday. I realize there are many special days, but today is your special day. Out of all the places you could be, the millions of people you could have celebrated with, you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can bring that joy a little back to you and make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans, and Cracker Barrel. Officially added to the list. Happy birthday, Kenda. Thanks for the birthday shout out, Kenda. Thanks for being here. Glad we could sing to you. Josh gives us a little lowdown. He says,
And then sobriety.
Hang on. He says, you need to go to, before you hit Judge Middleton, Judge Cedric Simpson. We'll get him queued up. Boom, boom, boom. Oh, yeah. We're going to back up. Give me a time stamp on this one, Josh, if you can. All right. Happy birthday. I hope you have just a wonderful birthday. Free pancakes, everything else. Selena says, could you possibly do a quick video if you're not coming back next time? Okay. Yes, I possibly could. I really possibly could. Drum solo coming up. Everyone will join with me in finishing this birthday celebration song. No, the party will not stop with a drum solo. Beautiful. That was probably one of my best. I'll put that in the top 5 as far as nailing the rhythm that time. Y'all did great. Thank you, dancers and all. Appreciate that. 80s, we saw with the exuberance with which you banged the cymbals and the crashes and all that. That was great. Or just a note on the community page. Kim, it's almost like somebody had invented a way for me to give you information, and I didn't use it. So I apologize. Let's see. We've got Simpson pulled up, but Simpson likes to go ahead and just delete everything without warning. So we're going to jump at the beginning.
Here, the Honorable J. Cedric Simpson presiding.
You may be seated.
Hey, Judge. Who moved your cameras?
Court does call the case of Dale Gretch versus Taylor Adams.
This is tenant docket stuff, but it might be spicy, says Josh. So Kim's like, it's
Good morning, Your Honor. Alex Barry Santoro appearing on behalf of Plaintiff Dale Gretch and Dina Davis, P81545. Nice to see you.
Good seeing you, sir. And this is, I thought, defendant's objections to garnishment?
That's accurate, Your Honor. I did file a writ of garnishment, and there was an objection served after the 14 deadline to effectively stay the garnishment. So I'm here today to
object to any stay of the garnishment. Right?
Yeah, that's the lawyer.
I'm brilliant. I figured that all out on my own.
Yeah.
And they're not here. Taylor Adams, Tiffany Gross.
Do you want me to call the hall or something?
Well, Adams, Gross.
No, I know them.
No.
Somebody forgot to pin the judge on the screen.
The defendant having failed to appear, the motion regarding the objections to the garnishment are denied. Garnishment may proceed. That denial is based not only on the defendant's failure to appear, but also on the merits of their objections.
Thank you, Your Honor. I appreciate your time.
Thank you, sir.
You had no merit. Denied.
Inmate Shin versus Fatima Stevens.
Is that the laundry lady? Is she back in court? It's the lady who just pled guilty?
Fatima Stevenson appearing on behalf of herself. Good morning.
Good morning, Your Honor. Jay McCurgy on behalf of Jing Mei Shin, P8321.
All right. And this is your motion for relief from judgment, ma'am?
That is correct.
All right. What do you want to tell me about it?
Counsel and I originally in late May, I believe, were discussing the option of me purchasing the home that I'm currently renting, because at that time I was made aware that the owner was intending to sell the home. So it would have benefited all parties if we were able to make this transaction occur. It has taken a little bit of time. We've all kind of, well, I can't say we've all, but counsel and I have corresponded through email, as you've seen. The property manager, who is also a realtor, and I and the realtor I had secured recently have also been in communications as of yesterday. I was just made aware late yesterday afternoon that the property manager who was in correspondence with my realtor and lender is not the listing agent. So therefore had no authorization this entire time to work on the deal. And so, anyway, long story short, I had not looked for alternate living. I had not, I wasn't intending to seek alternate arrangements to move out because my intention was to actually purchase the property. It wasn't going to be a quick thing, but it was going to take a little time. But as long as I showed progress and all the relevant parties that were interested were kind of kept in the loop to showcase good faith that we could move forward with that and stay the eviction.
Thank you, Your Honor. The home is not currently for sale. Hasn't been listed yet. My client wants to get the property back.
Somebody's moved the judge's cameras.
Okay, just so that I'm clear, the original is conditional order of dismissal.
Correct.
Was put into place with contemplation of a sale?
That's correct.
No, Your Honor.
One side said, yeah, that's correct. The other side says no.
Yes.
She was trying to buy a house from someone.
Stevenson is representing that we've been in discussion for sale of that home. That is not accurate.
Okay, but was there somebody well, let me ask this. Whether they had authorization or not, was there somebody operating on plaintiff's behalf that was leading toward a sale?
So there was a, after the affidavit was sent in late June, Ms. Stevenson sent me this email that she has, I guess, attached to this motion here, that she's been approved for a mortgage.
Okay.
And as you can follow through this email chain here, essentially, she wanted to put together an offer, and I said, if you're going to do that, you might want to do it quick because we're running out of time here. And that's essentially where that conversation ended on my part.
Right, but there were also other individuals that were.
Text messages, Your Honor?
Yeah, well, there are other individuals that are involved that are seeming to indicate that the purchase.
On the plaintiff side, Your Honor, there is a realtor who's the property manager who had asked Ms. Stevenson for a pre-approval letter or something at some point. Nothing was provided. I have an email chain here that I can submit for the record. It's called and it clarifies what happened.
Clarifies. Well, okay, so here's what I'm getting at.
there's someone on the plaintiff's side that is talking to somebody on the defendant's side regarding the sale. I'm a bit concerned because as I'm hearing you, the person on the plaintiff's side is a realtor, right?
That's correct.
There are, it seems to me, discussions that are going on regarding, between the person that's a realtor on the plaintiff's side and a realtor on the defendant's side.
So the person who's a realtor on the plaintiff's side has no agreement to sell the home. There's no.
I get the fact that there may not be some agreement between plaintiff and this person.
Okay, in no way does this person represent the plaintiff or their interests.
In some way they do, don't they?
So, Your Honor, I think the statement that this person is the property manager is incorrect because this person has told me they're not the property manager of the property.
Who are they then?
They help,
vis-a-vis the property.
They helped the homeowner purchase this home or find this home as a property for their portfolio.
Say that again?
They helped the homeowner find the home as a property for their portfolio. As an investment property, this property.
Okay. Okay.
Yeah.
So they were the realtor for the homeowner.
If that's all they are, why are they entering into discussion?
Your Honor, I don't know.
And why aren't you suing them?
If we look through, I have an email from that person in an email chain that both Ms. Stevenson and I were included on from yesterday, and it describes an email between her realtor and this other person describing what.
This other person being whom?
The person's name is Kirk Glassel.
And that's the person that now you're saying is nothing regarding this property.
That's correct, John.
Then why are they involved in an email chain?
This email, so Ms. Stevenson, I would say, was speaking to a realtor. This realtor reached out to this person they believed to be the real estate agent for this property, although that wasn't the case. And they had a discussion of this email that both Ms. Stevenson and I were.
Close up and no, go ahead.
Yeah, this email that we were both a party to verifies what that discussion was and that they, what they believe the intent of that discussion was.
If I could clarify one thing, Your Honor, in the email from counsel, it clearly states in the email that I had submitted with a motion for the recommendation was for me to send the offer letter to this individual in particular, and then
this person who now is being claimed to be nothing.
Yep, exactly.
That's.
I do have other.
Well,
that's
okay.
false.
Hold on, folks. This may make sense to you. It doesn't make sense to me. Why would she be sending an offer letter to somebody who really has no affiliation to the property?
Oh, I was thinking he would communicate that offer to the home. Should there have been an offer? Because I'm not.
Then, right, but is. Okay, Mr. McCurdy, that's part of my problem. Part of my problem is this person and your client may be saying they have nothing to do with the property. Apparently, the defendant believes they do and is operating with some apparent authority. And you yourself also may not know what that position is, but like you said, I'm not a realtor, but this person is doing something. And the very fact that the person is a realtor, I think that there is.
You acted as if there was a contract.
There certainly is the potential for some confusion regarding that. And I think that's part of my.
The lady behind the
have more recent communication as of yesterday with the same person.
With who?
With that same realtor and my realtor and the lender.
And the lender?
So if Your Honor, if I can clarify, I have an email right here between all parties just clarifying what has happened in an email. And the email includes her realtor, the email chain includes an email from her realtor, back and forth. I believe it's relevant.
Okay, but. Mr. McCurdy, the very fact that all of this needs to be clarified, isn't that a problem?
So, Your Honor, after I spoke to Ms. Stevenson yesterday, she made it clear that she was gonna believe that she's been misled here. So I reached out to the realtor to see what was going on.
Right.
If she hadn't misled, if there was discussions with the loan officer, if there was discussions with a fellow realtor, and what he described to me was something close to what we're talking about here, but not, but missing the target by a little bit. He believes this was a last minute attempt to confuse the situation and stay the eviction. And he clarified that in an email because the realtor who reached out to him had not signed an agreement with Ms. Stevenson. It was just an informal discussion about what, if that property were to be for sale. Now, he clarifies in the email that I have in front of me that he doesn't know where these numbers are coming from and that he...
What numbers? The offer?
Yeah, correct, Your Honor. Because no discussion had ever occurred about what that listing price would be. No discussion occurred about a wire transfer.
Okay, all right, but counsel, something's going on. I have two realtors on opposite sides, regardless of what their authority is. All right. I have two realtors, and then at some point, according to the defendant in this case, there are communications with a lender. That
The
go ahead.
realtor who may, or the realtor who's standing on the plaintiff's side had no, I don't believe had any communications with the lender for Ms. Stevens.
Is that right or no?
I have email here with Kirk Glassel in communication, several phone calls, or a few phone calls, I should say several, with my realtor, and she was relaying information between him to the lender. And there's including the good faith deposit, the amount of that, including something about a back rent that and all of these other components that we.
Okay. Okay, that's my concern. It may very well be, Mr. McCurdy, that your client gave no authority for this person to act in this fashion. But what's clear based upon the representations of the court is that they were. And I don't know.
Ms. Stevens has been putting forth since the conditional dismissal that she was wanting to purchase this home.
Mm-hmm.
After the affidavit went in with the order, I received this email saying, I've been approved for a mortgage. I'm going to try and put together an offer for this home. If any of those things are true, I don't know, Your Honor. Beyond that, no communications until the writ was posted to the door. And then all of a sudden this started as of last Thursday or Friday.
I've got steel-toed slippers. Does that count? Like they're slip-on, they're leather.
If Ms. Stevenson would like additional time, we're happy to accommodate her. We can make any arrangements she finds like reasonable, but I don't believe the writ should be overturned.
Screeners. Shots fired. So the homeowner wants to sell the house, but not yet, and not with this real estate agent who didn't have authority but did negotiate the deal.
Evidentiary hearing. I don't know when I can do it. When do we set the crime?
Apparently, the renter does still want to buy.
Okay.
And now might be able to.
After
Even though
that?
she's behind on rent, she can afford to buy the property.
Yeah. So,
Okay.
Yeah. Yeah, it's already at 1 p.m.
Got it. I understand.
LAG, I'm sorry to hear that. Bummer. There must be a better one out there for you. Hope it matches up with you quickly.
The problem that I see here is
it's not live streamed. There will be openings and closings. Is all I'm hearing. No actual trial.
There's something else that's going on, which, as the defendant has stated, led her to do or not do things. Plaintiff may have a different version that she's coming up at the last minute and doing whatever. Regardless of all of that, I have two realtors. I all of a sudden have a lender involved. I would just say that if Miss Stevenson has gone to those extremes just to delay, that's BS. It's a lot. I don't think that that's what she did. I don't think the communications that I've seen and the ones that are being described are that. Something, rightly or wrongly, it seems to me, was represented to her regarding the sale of this property. Okay.
Property was never listed. That's
right, but I don't. I hear you, but
properties are sold all the time without being listed.
If you had your, from the plaintiff side, your everyday run-of-the-mill property manager, not a realtor, they're just managing your property, make sure that repairs are done, collect whatever, okay? And she's having discussions with that person, then I might tend to agree that there's not enough there doing anything. This is different because this person's a realtor. And, by the way, I don't think somebody goes up when somebody's a realtor and say, do you have the listing? I mean, I don't know that comes out of anybody's mouth right out of the gate, unless it's the realtor that says that to somebody. You assume that they have the ability to sort of move in the way that they're moving, right? So I get it, but something transpired here that either Miss Stevenson was misled potentially, or something occurred where she just didn't understand it and how the transaction was going to go, or something. I think for your client, Mr. McCurdy, I don't know if she knows what the heck has transpired, because somebody is apparently, well, I'm not making this conclusion, but at least from Ms. Stevenson's perspective, somebody is acting on her behalf or their behalf. And it's just, it seems to me, doing things and making things that may be representations that have to stick to your client. But I don't know. Now, having said that,
so you need to
other problem, Ms. Stevenson, that you have is typically any agreement regarding the sale of property would need to be in writing, right? But so there may not have been an agreement, and that may be this court's ultimate conclusion. But I also realize that there are discussions that happen before there's any writing that's put into place. I mean, just in a practical sense. So, from what I've seen today, it's a
tax auction.
I think it would be improper and prudent on this court's part to issue them or to allow the writ to be executed. So at this juncture, the court is going to stay the order of eviction of the writ in this case. I'm going to order an evidentiary hearing on the issue regarding a sale. I will set that for August 11th, and I apologize for pushing it out to that point, but my docket is what my docket is, folks. And I'm going to try to take a vacation. Ooh. Or at least not be here. So August 11th, 2025, I will set that at 2 p.m. Okay, there's a criminal evidentiary hearing ahead of you, and I've got to take care of the criminal matter. But in the interim, I might suggest that the parties try to talk to get straight exactly what's transpiring on the plaintiff's side and what may have been said. Ms. Stevenson, you also, and one of the things that you said this morning is that you hadn't had time to make alternative arrangements regarding yourself. So I might suggest that you at least have a plan B, because I don't know what I'm going to rule on this. All right?
I agree.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
Okay, so we the lady behind the lawyer in blue.
I'm going to give it to Lee. Why are you up here?
She was, yesterday we saw that she pled guilty to assault, where she assaulted our renter in her property.
Yeah. Mm-hmm.
And now she has another hearing today.
More stuff.
She filed more stuff.
Okay. Yeah. Thank you. Court does call the case of VMC Rio LLC versus Nettie Whitlo and Yolanda Whitlo Tice.
Good morning, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks, occupant.
Pardon?
Doshia Banks, occupant.
Occupant?
Doshia Banks, occupant, Your Honor.
Okay. So you're not Miss Whitlo?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court, because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
right.
Creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
Judge is like, yeah. All right. Let me look at that.
Thank you.
Where's Mr.
I
Allen?
will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending.
What?
But the status quo as of right now is that there is no stay. And that order lifting stay holds until such time as the appellate court does something. Okay. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor.
He needs that vacation now.
There is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
there's more.
Go ahead. There's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlo, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlo that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that, because okay. I'm not.
The reason that I mention all of this, Your Honor,
go ahead,
is that this is $1 million house in Ann Arbor that Ms. Whitlo purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlo filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
She's nodding. Yep, this is true. This is true.
The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
That's a lot. That's a lot of rent. Ma'am, who are you?
Yes, Your Honor.
What do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh.
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and then you can go challenge it. With who?
With Whitlo. Ms. Whitlo.
Then you need to go against Ms. Whitlo.
Pardon me?
Then you may need to go against Ms. Whitlo. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but.
Well, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting.
You're recanting what?
What I just stated.
Which part?
The part that
turn her up. I'm recanting.
That I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that.
So you are consenting to this court's jurisdiction?
At this moment.
Oh. Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay.
This is so good. She's like, wow, this wasn't on the internet. What do I say next? She wants to just continue.
If I may.
No.
I do have time, I do believe, to go file an answer and counterclaim. I was just led under false.
Answer and counterclaim to what?
To their complaint for eviction.
Okay, they do have an eviction, and she says she's an occupant, but she's not a named party, so she shouldn't be an occupant.
You have a lease with, allegedly, with Miss Whitlo.
Correct.
Then that is who you need to pursue it against.
Okay.
Or whatever the heck you're doing.
Well,
because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
Okay, I'm not really understanding, but.
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case, and grant an order of a judgment and an order of eviction in 10 days.
Okay.
Any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
Okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. So
I wondered if Ms.
basically the notice of removal that the Whitlows did,
they are not here. I don't know
if they even exist.
I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so, as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
Okay.
I think she is Miss Whitlo. That's just my gut feel.
Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No,
You're telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay.
How does one sue oneself for somebody else's property? Would have to Google search to find that one. The longer you stand here, it just wastes your time and the judges.
All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
Thank you. We'll await. I did.
My rent wasn't that high.
No, I don't think so.
Rose with thorns, I got my orange
Mr.
back.
Fink is ready on.
Mr. Fink, are you ready?
Awesome.
But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute.
Why, Judge? Why is your head hurting?
Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Court's in recess.
All right.
Okay. Apparently, real estate scams are still a thing. Still a thing. We're gonna skip ahead because we've got more stuff coming up with the judge here in just a minute. We are waiting for the laundry lady to make her appearance today. I'm not sure when that is. But wow. The Whitlows, who apparently were trying to scam or defraud the owners of the property, then sublet the $1 million house out to make money there. So they were collecting rent from somebody who was in the house, but they were not paying the property owner. And they didn't show up for court. They're being evicted. This lady's like, well, I was renting from the Whitlows. Oh, man. And she's a sob sit. She's like, I don't recognize courts. I was like, bring that up with the Whitlows. Oh, man. Crazy. Haley's Comet, 16 months. Yeah, Judge, what do you take for a headache? Isn't there a commercial about that? That vacation needs to come very soon for him. And then the recant. Oh, my goodness. I don't know. I'll recant at this time so I can speak to the court, and then I'll not recognize you. Judge is like, nope, that's not going to happen. Oh, my goodness. Good stuff. Good stuff. What's in the water up there? What are y'all doing? What are you serving in the water that's making people go crazy like this? Someone fed her that speech. Yes, someone on the internet charged her $5.99 for that advice, and it was worth not even the money it was printed on. Judge, if you can mic up, that would be great. Florida as well. Yeah. This is the best response ever. I don't recognize the court. Then get out. I don't recognize you then. Works two ways. What's with top fans? Why is everyone getting top fan stuff? Let me see what we got here. Looks weird, but let's see. We've got Kelly H number 1, Virginia Little number 2, Selena K number 3, Kim R, Tandy K Ortiz 5, Teresa 6, Greeners 7, JP Rabbit 12, Mindy with Love. Sorry, JP Rabbit 12 was 8. Mindy with Love is 9. Rose with Thorns 10. Camilla Julian 11. I don't know. I've got the top 50 up here showing up. When I can clear it. Oh, that's points. That's the top 15. It says clear. I don't want to clear it because then Kelly would be super mad. But see, like Selena K's, if you look at her message in the chat, next to it has a little, or for me anyway, it has a number 2 and a crown. Kim says, I'm number 2. Kim. It's weird. Sometimes the little top fans crown appears, and sometimes it doesn't. I think the crown is from YouTube. The points is from Lumia Stream. Yeah, he's taking his time. I need to fast forward a bit till we get some audio back. Let's see. Still no audio.
Thank you. Okay.
This lady in white on that first row behind the guy in white.
And you got your clients here.
Yes. Yeah.
Okay, so why don't you guys stay here?
Okay.
I'll do that, and then where is
Are you gonna, Your Honor?
Pardon?
I have an interest in the Anderson v. Lyman case. So are you going to hear that while we're in back? I can watch it later if you are.
No, I'm going to try to get through some of this and then get to that one. And Ms. Lyman is here. Where? Pardon?
One of them.
Oh, okay.
I'm going to see if we can fast forward just a little bit.
Where are they going? They're just busting out in this. So here's the deal. You got to watch her. Okay? Yeah. You got to watch her. It causes a lot of problems. They can go ahead. You can take it back. I just point out trouble when I see it.
Take a photo of the order you just signed on the Kaiser case.
Say what?
Can she take a photo of the order you signed on the Kaiser case?
No, I didn't get a copy of it. I just wanted a copy of the record. What? I know, I'm just being really difficult this morning.
You are.
Or is it already?
When I have no idea.
Oh.
No. When we'll find a way to get her a copy.
Okay.
She'll be here for a minute.
Thank you.
Okay, we're going to skip forward a little bit.
Okay, now as to Ms. Bauer.
Yes, Your Honor.
As to the cases involving Mr. Fink, he's now left, but legal services is involved with all of those.
Yes, it would be O'Day, McFarland, Turman, and Jordan.
Okay. Because I had 4. She took my files down there. Okay. Then what I'm going to do is I'm going to stand in recess. I'm going to talk to the plaintiff first. Then I'll come back. I will get to you guys.
Okay.
All right.
Okay.
All right. Thank you.
Stands in recess, comes back. Let's see. Waiting. He's still gone. All right. So we're still waiting for the laundry lady. A quick catch up. If you missed yesterday, the laundry lady, the lady in white on the first row there behind the gentleman lawyer who was speaking last. She rented a house to somebody and had a finger tussle, a finger maneuver. What was it? What did they call it? Was it a finger tussle? There was some finger related things happening, finger tussling between the two of them over a light switch that raised to the level where the renter, the young male, filed criminal charges against her, and she was facing assault and battery charges for fighting over the light switch. Now, the light switch was part of the battle because she was trying to get him to stop doing laundry after 9 p.m. because it was like midnight, and he was in this shared house where they all have different rooms, and he's working the laundry. He needs the laundry for the next day for work, and the dryer's going, and he starts the laundry, and she comes in, turns it off. He hears it off, goes down, checks, still wet, starts it again. She comes back and forth. And yeah, so that happened, and she fought this. She went to court. She got a lawyer. She fought it. He testified against her, and he got yelled at by Judge Simpson. And then she testified in her own defense, and she got yelled at by Judge Simpson because both of them are just terrible witnesses in court as far as what they're supposed to do and what they're not supposed to do. And then after finishing her testimony, and the judge takes a little break, she decides to plea. She takes a plea. She takes a guilty plea as charged, is what it was, and now she's pled guilty to the assault, which she said didn't happen. She claimed that she was the one who was assaulted previously off camera. We had the video and everything. Now she's back, and with that fresh in our memory, we're waiting for her case to be called by Judge Simpson. Let's see. We are trying also to. Follow a little burglary case, and it's not working very well. Hang on, we've got to see where this is. Struggling to find it. Let's see if we can use this one here. I'll have to tweak it quite a bit. All right, hold tight. Let's see if we can get access to this burglary case. Source 3 will be 8. While while we still wait for Judge Simpson to come back. Four is MP1. Hold, please. We're still trying to figure this out.
In front of the Walmart.
In front of the Walmart. Where's my other camera? Oh, two. Two needs to be off. There it is. Found it. How's their audio?
Under Minnesota law, news agencies
that's terrible.
may petition the court to have a video camera and still camera in the courtroom during a trial to audio and video record and photograph the proceedings.
That's terrible. That's like recorded on a potato in a tin box. Tin can court for sure. So we'll hold on that for a second. See if we can get this any cleaner. Yeah, they have too much of it. It's too much sense. Why are they doing this? It's audio better.
Did what she admitted to.
Okay, I'm bailing on it. It's also, they block out all the evidence. They're blocking out the evidence. We can't see it. No video. All right, where are we at other than that? I think we were going to go to Judge Middleton. I need a bigger mouse pad. Judge Boyd is up. Let's check in with Judge Boyd, shall we?
For inspection.
Okay.
And without telling me what it is, do you recognize it?
Is one, I believe, is a copy of the report I wrote in this case, or is one my CV? I can't.
It's either my report or my resume. I'm not sure what it is.
There were two attachments.
Yeah, I'm sorry. I'm trying to pull that up. Exhibit 1 is my CV. So this is a copy of kind of our resume, our curriculum vitae. So.
And is this a fair and accurate depiction of your curriculum vitae or CV?
Yes, ma'am. It appears to be.
At this time, we are offering into evidence defendant's exhibit 1, the curriculum vitae of Dr. Stephen Thorne.
The state would just object on Thurston County. He's here to testify about clarifications.
If I could, and your objection to is what?
Just Thurston, Your Honor.
All right, that objection will be overruled. Defense exhibit number 1 will be admitted.
And Your Honor, pursuant to the Rule 702, the Texas Rules of Evidence, I am tendering Dr. Stephen Thorne as a qualified expert witness in the field of sex offender risk assessment.
He doesn't have an objection.
All right, then that will be granted, and the court will note that he's an expert in the field.
Is that a real Louis Vuitton?
Dr. Thorne, are you familiar with the specific risk assessment tools used in this particular case?
Yes, ma'am.
And how does this particular risk assessment work as it pertains to Mr. Whitlo?
Well, they allow us to kind of collect information relating to risk factors. Like, and I'll try to give a short answer, but
hang on, we've got a spam
in
call.
doing a risk assessment, we look at are there any factors that the research?
Hold, please. We've got a spam call. Hello? Hello?
Hello?
Hello?
Hey, my name is Daniel. I'm calling from affordableinsurance.com. And the reason why I was giving you a phone call is because we're looking to save you up to 30% on what you're currently paying for your auto insurance. You are currently paying for auto insurance right now, correct?
They keep sending me letters to pay for it.
Hold on just one moment, okay?
All right.
If we could get you a better deal than what you're paying right now on your auto insurance, would you consider switching?
I'm sorry. Do you have someone who can talk a little slower? I'm having a hard time understanding you.
Hold on just one moment, okay?
Thank you so much for calling Auto Court Visit. How are you doing today?
I am doing well.
But you heard that? Well, let's start by confirming some information to see how much we can save on your auto insurance. So may I have your first and last name?
They say I shouldn't give it out over the phone.
Sure, I'm the verifier here. I will verify you a couple of details, then patch you with a licensed agent. Okay. So if you don't give me the name or information so I cannot assist you further, I will give you a call back.
My name's Dwayne. Dwayne. All right. I got through the AI, but he's a licensed agent. Yeah. He's going to call me right back, I'm sure. All right. All right. Where were we?
Suggest can increase a individual's risk for sexual recidivism or decrease an individual's risk for sexual.
Okay. So we were going to jump somewhere else. Apparently not there. Why are we striking out so much? Why are we like it's like I came back from vacation and nothing is working the way it should. Okay, they're still up. We don't want repeat offenders. Let's go to Judge Raquel. How about Raquel? Take this full screen, please. There we go.
Yes, I do. And that's what you want me to do? Yes, drop the case, please. And you're asking Judge West to allow me to drop the case? To drop the case.
All right. All right, you can step back.
Thank you. And Judge, just for the record, if I may, obviously with those facts, obviously the court is aware of experiences you and I both had in the past. I think there was something more to the incident. She's obviously not going to cooperate with me. She's obviously also his spouse. And so at this time, with the court's permission, I would move to dismiss, but I just wanted to be sure all of that was on the record so that if something were to happen in the future, everybody is aware that those were specifically her wishes.
All right, if that comes through based on all of that, I don't know how you can do anything else, and so I'll sign that. Mr. Franklin, I'm not sure what, if anything, happened. My thought is something did happen. Hang on, just let me talk, okay? Don't talk yourself out of this, because here's what can happen. It's not easy, but it is possible to go forward with cases without the complaining witness. So whatever happened needs to not happen again. You need to get a grip on whatever anger, whatever issues you have. If you've got someone here that cares about you and you want to be a part of their life, that's not what you do to people that you love. And it's definitely not what you do where there are children involved. Do you understand? All right, go back with the bailiff. Yes, ma'am.
You want to know what my setup is, Lucky 13?
Mr. Parker, you have Tracy Haynes.
I can tell you the setup. I have one of everything that Apple sells. I have duplicates of some things they sell. And Blackmagic Design ATEM switchers. I can give you a list if you want. Shoot me a text on the burner phone and I can give you a list of everything. If that's what you're looking for. Case dismissed from a previous one. Not sure what the charges were. Sounded like some sort of domestic. Because of an uncooperated witness, and something the judge has seen.
Good morning. Are you Tracy Haynes? And this is cause number 240514. I'm going to take judicial notice of the court's file. Mr. Haynes was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from them dated June 23rd of 2025 with that report from Dr. Samantha Guzman with the opinion that Mr. Haynes has achieved competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No.
Then at this time, I will find Mr. Haynes is competent to stand trial. And will he waive the formal reading of the indictment, Mr. Parker?
Yes, Your Honor.
What's he looking at?
And are we going on count one only? Hold on, let me get it correct again. All right, Mr. Haynes, in cause number 240514, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation from February 3rd of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
The stuff on the computer.
The stuff on that computer
no.
tablet?
No.
Did you go over that before you signed it with Mr. Parker?
Yes.
And do you understand those documents that you signed? Speak up, please.
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow your agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. Speak up, please. When you're answering, I need you to speak up. State tenders number 1.
No objection.
It's admitted. All right, sir, I'm going to find that you entered your plea of guilty to count 1 freely and voluntarily. Find that you're mentally competent again and that you understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, and sentence you in accordance with your agreement to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
She got it all memorized. We got a little trial out of Thurston County, Washington, that Josh has found for us. Case starts at noon. We should be able to get to the preliminary stuff.
Mr. Parker,
first.
you've got Jack Hooper.
Let's see if I can get to that right now. Means we might miss the laundry lady in Cedric Simpson's court. Let's do this. Let's do this right here. Ready? Let's jump to Thurston County, Washington for some preliminary stuff. This
you
case
will,
starts
however,
this
need
afternoon.
to make motions. If you hear a question being posed, who is in violation of the motions in Monday.
Understood.
It's the one we were waiting for the other day. This is preliminary stuff. Did I miss, Josh, do I have to back up further than this? This guy almost didn't show up yesterday, I think. Almost like a Mr. Farag. Same courtroom.
You have reviewed the poster instructions?
Yes, Your Honor.
And did you have any in addition you wish to submit?
No to the jury instructions. However, as I was sitting here earlier reviewing the case report, it occurs to me Mr. Hoffman was not on the list of witnesses that the prosecution filed in June. And I do have at least an oral motion to limit or requesting to prevent the prosecution from inquiring or asking about details about a previous incident that is referred to in the police report. It indicates that the call was made to trespass Mr. Snarley, and they're referred to a previous call and there's a case number in the police report from July 26, 2023. My understanding, Mr. Snarley has never been charged with anything from that alleged date nor convicted, and so any details of that alleged incident I would request be
excluded.
Yeah, I don't see any case reflected on the record from July of 2020.
Correct. So it was a report filed, and so specifically this incident occurred because the reporting party, Mr. Hoffman, called because of a previous call.
Okay. So at the previous incident in July, Mr. Snodley was trespassed from Home Depot.
He wasn't trespassed. There was a report filed of an allegation in the police report indicates where he shoplifted, but there are no charges from that date. But that is the reason he was calling to trespass him on this date.
Okay. And Mr. Weston, the city's position on that?
No objection to the prior incidents. The state wasn't going to elicit anything about I believe the report mentions two priors, one from the Olympia Home Depot, then a prior incident with the specific loss prevention officer that I will be calling. I will be asking the loss prevention specialist whether he knew the defendant prior, and he's going to be like, and I assume what I anticipate him saying is like, yeah, I've seen him at the store for a prior incident or something of that sort, but not any details about the prior incident itself. Just that the store employee, loss prevention specialist, knows who the defendant is and has seen him before.
And did Mr. Hoffman have contact with Mr. Snodley on this date?
Yes. He was one of the loss prevention specialists that was monitoring and surveilling the defendant in Home Depot, and ultimately was there with the Tumwater officer when they encountered the defendant.
And is it going to be his expected testimony that he was watching Mr. Hoffman because he was aware of a prior incident involving Mr. Hoffman?
Something of that sort, like he's seen him before in the store. There was a prior incident, but not going into any details about that prior incident. Just being like, I know who he was. I've seen him before. That's how I recognized him. And then we continue to monitor him.
Yeah. Mr. Pester, your thoughts on that?
Your Honor, I feel that any reference to someone testifying as a loss prevention officer to a previous contact is going to involve the implication that there was a previous theft or shoplift allegation against Mr. Snodderly. And so I guess I would object to
it's prejudicial.
Mr. Hoffman testifying to that at all.
And is Mr. Hoffman going to testify that he observed at this, on the date in question here, that he observed Mr. Snodderly take actions which led him to believe that he was taking property from the Home Depot?
That's my understanding, Your Honor.
All right. I can't conceive that a jury, if they hear that Mr. Hoffman knows Mr. Snodderly from a prior contact and thus was paying heightened attention to him, they are going to, in their mind, say, oh, so he did this before, and they're watching him when he comes in the store. I don't think how they could not think that way. So
good call, Judge.
Not mentioning the specifics of a prior incident doesn't obviate the appearance that Mr. Snodderly did this on a prior occasion, and it's going to be used by them to say, well, of course, then he did it on this occasion too. So I agree with Mr. Pesdirk on this one. There's to be, and I don't think it serves the state's case other than to have that implication. There's not an identity issue here. It's not like, I'm not sure which among three people Mr. Snodderly was. So since identification is not an issue, I think it inappropriately raises the past incident to prove the current or present incident.
So I will time a little bit.
So not mentioning the specifics of a prior incident doesn't obviate the appearance that Mr. Snodderly did this on a prior occasion, and it's going to be used by them to say, well, of course, then he did it on this occasion too. So I agree with Mr. Pesdirk on this one. There's to be, and I don't think it serves the state's case other than to have that implication. There's not an identity issue here. It's not like, I'm not sure which among three people
not a sponsor
Snodderly was. So since identification is not an issue, I think it inappropriately raises the past incident to prove the current or present incident. So I will order that there not be any mention of the past incident, which sounds like it would likely come up in Mr. Hoffman's testimony if he's not instructed by you prior to him testifying. So make sure that he does not mention a prior incident. He can just talk about what he observed on 23rd of October.
Understood.
Understood. All right, we are recording Cedric Simpson in the background, so we don't miss the laundry lady's appearance as we're getting prepped to watch the shoplifting case out of Thurston County, Washington, which always seems to deliver with the seemingly just like the simplest of cases can turn into the most bizarre courtroom theatrics. And we just have the feel that this one might be one. I see Judge Simpson. We've got him on save. I know he deletes everything as soon as he's done. We're saving it, so we'll be able to go back. He's not handling the laundry lady case yet, but I will have that for you as soon as it happens. So you won't miss it. You won't miss Simpson, but we need to just get this preliminary stuff out of the way. Is this shoplifting case from Home Depot is about to? Is it a Home Depot? No, he doesn't have an apron on. I thought he had you said he had a Home Depot apron. I was believing you. That would be funny. Katrina, I've got Judge Simpson over here.
Federal case
I can see
pending.
him, and I'm recording that, so we can go back and watch that. What trial are you going to do after the Valle trial? I don't know if we're going to follow the second Valle trial.
If Mr. Snodley chooses to testify, he says anything by way of testimony. Well, I'll just leave it at this. He's opening himself up to Mr. Weston, arguing that he should be allowed to discuss the prior incident.
Understood, Your Honor.
If Mr. Snodley testifies. And I'm saying this because I know Mr. Pasterka knows this, but I'm wanting Mr. Snodley to hear this clearly, so in his conversations with Mr. Pasterka, he can make the appropriate decision for themselves. If Mr. Snodley testifies and opens the door, then I may very well allow Mr. Weston to call Mr. Hoffman, recall Mr. Hoffman, and have him discuss the prior incident. That being said, are you now prepared to say whether Mr. Snodley is going to testify or not testify?
Not at this time. No.
You're not prepared, or he's not going to testify?
I'm not prepared.
If he does testify,
Just leave
crazy.
Going through the jury instructions, I'll leave blank at this moment the one whether Mr. Snodley is going to testify. And
let me mute the judge for just a second, because Jenny Georgia, let me read you something really quickly. This is actually from Twitter, from the 18th Judicial Circuit. Let's see, 18th Judicial Circuit Attorney's Office. That's at DA 18th is the Twitter handle. As a friendly reminder, the judge is not opening the public live streaming feed for James Craig's trial. For anyone wishing to gather information about this case, you can attend in person in Division 201 or request court transcripts at a future date. The judge has locked that one down. I am approved media in that division, and they're allowing opening and closing statements to be recorded, possibly not even shown live. But that's it. So that trial, you would have to be in person. Not liking the trend we're seeing from judges right now. So.
Yes. So we clear. All right, we'll see you, counsel, for jury selection at 2 o'clock.
At 2 o'clock?
At 2 o'clock, 2:45 for Mr. Snow.
Okay.
So they break for jury selection right now. We've got a couple preliminary rulings. We don't know if the defendant's going to talk. They did then select a jury. Oops, let me go back here. They did then select a jury. We're not going to watch the jury selection. We have watched in previous times. Why is that not working? Oh, because I'm on the wrong device. Previously, we have watched jury selection in this court. It's a lot of fun. We're not going to watch it for this particular trial. Let's see. Let's jump over to Judge Simpson while we wait just for a minute.
In addition to the clerk of the court in the future with the 7-day, or no?
You know, you can do that for your protection. Maybe you should do that, or just send it maybe to my chambers like 10 days after or something along those lines. But the bottom line reality is people have to do their jobs. I mean, the rule, yeah, we can all go around it, but the bottom line is somebody has to do their job to get it to me. And they did it twice that I'm aware of. So whatever way you, and that was very flippant of me to say it that way, Ms. Kim, because I do take this seriously. whatever way you see as being able to protect your interest in making sure orders get entered, I think you know how I operate. However you get it to us, I'll take care of it, my staff, and we'll try to deal with it.
Thank you, Your Honor.
I hate setting up a different process because people don't do their job, but you got to do what you got to do. All right.
Gotta do it.
Thank you, Your Honor.
Thank you, folks. Court's in recess.
Why, Judge? You had recess after recess today. Let's see if Judge Boyd is.
Tell the truth.
Yes.
And
What is my audio?
when you
doing
tell
on
the
this?
truth, it doesn't negatively impact your brother. So the fact that you don't believe that he didn't commit this offense, that's not going to negatively impact him. I'm just trying to get some
I've got to figure out why my audio is doing it on that channel and only that channel. Okay, I think it's through the switcher. All right. The issues we've had with the honor killing trial is that the case is almost entirely based on videos that were shot at the time, and the judge has ordered that no videos can be live streamed without them being obscured. So it's just constantly video after video after video where we just don't get to see and we just get to hear something. They've also, in the judge, in the senator accused of burglary, have done the same thing, and it's constant just cutaway. We're not allowed to transmit this part, not allowed to carry this part. So the downtime is just too much for me. I just don't want to. I don't want to have to imagine what we'd like to see and talk about how much it would help to actually be able to see the evidence. So we're going to try to find something else for y'all. We should have been prepping for Koberger, who took a plea deal. So that was nice. Let's go here to Judge.
the reset form. Just have a seat.
Have a seat. Everyone have a seat. There's plenty of room in Judge Boyd's court. We may be able to watch a verdict in the honor killing one. That'll be interesting.
Who's here on Adrian Holmes?
Sandy, the problem is they can get
And where's
all
Mr.
of us
Holmes?
kicked out of court.
Down.
Like it can shut down the live feed. If the judge hears about it, then everyone gets kicked out.
I'm so
Even the
sorry.
people who
There's a
didn't do anything
report
wrong.
that's due, but our system is down, so I can't see
Got
it.
an update for you.
Okay, yes.
I stopped by Judge Rodriguez this morning, and they told me that the evaluation is scheduled for August 21st.
The Aurora, Colorado trial, the judge has ordered no live streaming.
We're already on the computer. I haven't
Okay.
Didn't sign anything for it. I think it's September 7th.
All right. Mr. Holmes? Yes.
It's working for me.
Oh, it's working now? Oh, thank you.
I think it might be more.
All right, let me see. All right, Mr. Holmes, I'm so sorry that it's taking so long to do the evaluation. We have a limited amount of doctors to hear cases, and sometimes the pay for the doctors is not sufficient for what they do. So many times doctors will do some of these cases as pro bono. I'm sorry, just 1 second. Yes, so many times doctors will take these cases as a part of their clinicals and they won't charge. Yes. But we have a limited amount of doctors in Bexar County, so the soonest we can have you evaluated according to the court that is in charge of the evaluations is August 21st. So we do have a prior setting for you in this court so that I can make sure that we stay on top of your settings. Oh, here it is. Okay, let me see. Ta-da!
Ta-da!
Thank you, Rick.
You're welcome. Appreciate you, Rick.
I'm sorry?
Right now, can I have my time proceeded to August 21st?
Oh, well, here's the problem. Because of the nature of your offense too, and also legally, once there has been raised an issue of competency, you have to follow through with the competency evaluation. So legally, there's nothing I can do.
The doctors advocates, the doctor association. It's about the doctor association. Excuse me, I just woke up. Yeah.
All right, so this is what I'm going to do. Norma, he's scheduled for an evaluation on August 21st. Can you just recall this after August 21st, please?
No, I'm going to miss the appointment.
I looked on the computer last night and I think it said we already had a date for September 2nd.
Now, September 2nd, that may be, let me check.
Okay.
Yes. So that's not for this court.
Yeah, the court said they have 30 days to get the report in once the evaluation's done. So.
All right. So this is what I'm going to do. I'm going to recall this, Norma, if you can give me a date later in August, please, so that we can make sure the evaluation actually happened.
The only thing left we have in the bathroom is the finish trim around the doors.
Are you available on the 25th?
Floor. And
all
the
right,
shower.
So we'll come back on August 25th.
We just got
the,
right, the shower door just
sir?
arrived, so we have to do the walls and the door.
As long as I've been doing, and August 25th.
That's day we'll come back here.
I'm thinking I was hoping that's nice transfer.
I think he had a question about credit, jail credit.
So here's
and when your case gets resolved. If and when your case gets resolved, you're getting credit for all the time you locked up. Thanks.
All right, Mr. Holmes. Mr. Holmes, what I can tell you is what you're charged with, the range of punishment for that offense is 2 to 20 years. So the time that you're in custody, go towards the 2 years if that's some sort of an agreement that is reached.
Okay.
All right. All right, Juan Aguilar. Thank you.
This is a case on requesting a plea deadline. We're on the discovery.
Okay.
I believe I've received all the discovery.
Okay, it's set for a plea deadline today.
I'm born Judge said discovery.
All right.
That's my form was.
All right, that's incorrect. But what we'll do is I will set it for another plea deadline date. How old are you, sir?
I'm 26 now.
All right, Ms. Ferguson. If we can recall this back in 2 weeks for a plea deadline date, please. Is that good for you? July 29th?
Can we come to 30th since I'm here on that other case?
Yes, we can put it on the 30th. We already have 2 cases on there. I know, I'm so sorry. Yes. See, you know what? Give a mouse a cookie. He's going to want a glass of milk.
Pretty much.
It's a good book.
That is so true. You know, I didn't know that saying until I got that book for my niece.
It's a good book.
And I was like, oh my goodness. All right, so once you sign the reset form, you are excused. All right, thank you.
Thank you.
Number, what page is he on? Thank you. Who's here on Lamone?
If you give him Musa Muffin was the first one. I think I've read both. Just drive the last nail in by hand painted
All right.
gold.
On this case, where are we on Discovery Council?
On discovery, Judge, believe it to be sufficient. I know it just got indicted recently. His first court date, I guess, is scheduled for August. I think we're here for the compliance hearing with regard to pretrial violation report.
All right. Does anybody have a pretrial violation report on Lamone? No, I have nothing attached. This is all I have.
Oh,
thank you. All right, have you had a chance to confer with the state?
Yes, Your Honor. I did confer with Mr. Pitlock, and I brought to their attention the concerns of pretrial services. I actually spoke with Officer Grosso yesterday as well, Judge, and I know there has been some positives, BRACs. My client did admit to pretrial services that he did have a relapse. Unfortunately, he did recently suffer the loss of his father 2 weeks ago, and that was a stressor for him. He is a veteran, Judge, and he has been seeing the VA. So he's being seen a doctor with the VA, and he does have a scheduled appointment this Thursday. Since he is already set up with the VA and he does have some issues that he's dealing with, Judge, we wanted to see if this court would entertain doing a referral for veteran treatment court. I did notify him on the outside of the door that there is that screenshot where you can take and get more information. So he has been looking into that, Your Honor. But I do think that would be a possible good resolution to get him set up with that treatment, veteran treatment court, since he is dealing with some things and currently set up with the VA. So I did speak about that idea with the states about addressing this and moving forward in terms of potential treatment response. And they seemed on board with that possible route if he does qualify for that program.
All right, so you're not allowed to drink alcohol. Do you understand?
Yes, Your Honor.
All right, so this is what the court is going to do. I'm going to order that you be continued on the PAM device. There's still no driving. I'm asking that the fees be waived. And you're going to do 90 sober meetings in 90 days. Do you understand?
Yes, Your Honor.
Here's the thing. With these sober meetings, if there's an issue and you feel that you're going to use or there are stresses in your life, that's when you need to contact the VA. That's when you need to contact whoever your sponsor is. Do you understand?
Yes, Your Honor. And
I'm going to put it in this order so they'll know. We'll do a referral to veterans treatment.
Thank you.
We just put in a call to the AC people to come back and fix our AC upstairs one more time.
All right. And Norma, on this case, could you do a referral to felony drug court? Tell them that his case is still open. Veterans treatment court. And can I have a 30-day reset? All right, we'll be back on August 14th.
Thank you, Your Honor.
All right, thank you. Once you sign the reset form, you are excused, and make sure you follow through on everything. You understand?
Thank you, ma'am.
You're welcome.
We're putting in a new drain line. It filled up once again and flooded my son's wall once again. And so we're putting a new line draining out the other side of the house. There's something wrong with the other line. Van's t-shirt is not court appropriate. Generally with veterans, judges give a lot more leeway. It's going to be working tip-top just in time for fall. That's how ACs work. I'm tempted to go rerun all the vent lines, put in insulated lines instead of these drier vents we currently have. Purple or real estate. How to sell an old house is the one I think I need to start. Judge Simpson is still in break, waiting for him to come back. We'll watch for him so we can get the laundry cam going. And we're also waiting for our trial to start, which should be in about 8 minutes out of Thurston County, Washington. It looks like we just got a feed.
Well,
right
it sounds
now. And it sounds terrible, so I'm going to fix it. I'm going to get rid of that tinny sound. Just 1 second. Thurston County 4. There we go. All right. Tinny sound gone. We're now waiting for court to start. Right here. People are coming in as we speak. Sweet. This is the Home Depot shoplifting case, which we watched a little bit of the prelim decisions. They cannot mention there was a previous incident in this particular. Yes, that mic's on. We'll hear you. The particular loss prevention ambassador. Is that what they are? Loss prevention ambassador. Recognized him from a prior incident. That cannot be mentioned in court unless, of course, the defendant takes a stand and opens the door. And once that door is opened, then it can all be brought up. And, of course, that will not end well for him. You don't want to be recognized by the loss prevention guy at Walmart unless you're related.
Right. And you were a lifesaver, and you had a problem.
In front of the Walmart.
Yes, I was waiting for a text. I had a paper hanging from my desk. Yeah.
Okay, points balance for Trixie. She's ranked 25. Let me just look and see.
Yes, sir.
It's a different balance than what I have.
General.
So these points have nothing to do with the like Kelly H, who's ranked number 1 right now. They're two completely different point systems, and I don't know how either one of them work. The crowns you see in chat are constantly shifting. I think it's just
morning. It's a matter of
in the last 10 minutes who has done the most chats.
So, but yeah, I think I don't anticipate them taking on because they're not allowed to talk. They're not allowed to. So yeah, so basically, we're just
If they keep talking, I'm going to mute them. If they actually start talking about attorney-client privilege stuff, because there is no one else around. There is some sort of expectation of privacy. I think he was just sort of telling them what's going to happen today. Why do potatoes take so long to brown when frying? LEG, try using real butter. Generally, I think that helps. And turn up the heat a little bit. Jackie C says, darn, I don't get crowns and such while lurking and working. It's all right. They're pointless. The points are pointless. Can I get a quick summary of the case RA is going to follow? Valerie, this case right here is a little trial out of Thurston County, Washington. I believe this defendant, if I remember correctly, yesterday was supposed to be in court and was late and just wasn't showing up. And the judge he said, if he doesn't show up within this time, we're gonna arrest him and hold him in jail for the duration of his trial. So we make sure he's here. But then he did show up in time. So we thought we might have a Mr. Farag on our hands, one of the defendants from this very courtroom who went missing during the lunch break of his trial and has yet to return, and that was months ago. So We'll see. This is a Home Depot shoplifting case, a small one. This court seems to have just the funniest little things that happen here. It does feel like we're in the Holiday Inn Express courtroom, and we'll see how it develops. Wesley, aka Breezy, correct. It's a YouTube thing that will show people how to interact with chat and super chats, etc. It's a new feature, kind of fun to chat and get the #1 crown. I don't know the time period it looks back, but it will re-gift the crowns frequently during a live stream. Sonfall, I think I may have made too many. There's no such thing as having too many potatoes. I would suggest, just my personal advice, let them cook a little longer. Don't stir them as much. Let them get a good crisp layer on them, and then flip. Mr. Frog has rehomed himself.
Good morning. I'm still going to show you real quick here. Okay.
Prosecutor's here.
I'm going to show this to the jury and just walk people out of the store. He said, "Pass them in." Just tell what the checkpoints are, exits, things like that.
Police officers here, probably the one that trespassed him.
Is this the front of the store? I'm sorry, this is the front. So main entrance, lumber entrance, garden entrance, check stand right there, back of the store.
Danny, not sure exactly what he took. I'm guessing it was probably over $100 in value. Wrong answers only in chat. What do you think he allegedly pilfered? They opened the pool and salad bar. The pool's open right now. Jury's swimming.
You want to get it marked and stuff? Yeah.
Paint stick. What's interesting is Lowe's, there are some paint sticks you get for free and some you have to buy.
Amy.
Yeah.
I have a thumb drive.
Okay.
That's going to be marked as State's Exhibit 2.
Okay.
The picture on it is just a layout of the Tumwater Home Depot. Usually you guys mark it after because I'm going to be using it. So do you want to mark it before? Okay.
Stole the job applications, all of them. A toilet brush, hot tub, and a tiki bar. Candy at the checkout. Oh, Lone Star. Oh, no. I hope your son's okay. Pregnancy test. Does Lowe's sell pregnancy tests? There's probably a joke in there somewhere. What is it in the plumbing section? I don't know where that would be. Cancun peanuts by register 3. Toilet paper. The only issues was with evidence we can never see the video. Right, we're not going to be able to see what happened. It's going to be described to us, though. One singular screw. Okay, I am paranoid. Honestly, this is like new fear unlocked for me. I'm paranoid of being accused of stealing something from a store.
I have that.
You think where I can't open it.
Oh.
It's a thumb drive. And so if I have to take something into the store to like match it, like a pipe fitting or something, when I walk through the door to the store, I carry it and hold it up to the camera. I'm like, hey, here's me entering the store and I have this in my possession coming from the outside. Does anyone else do this? I don't like keep it in my pocket and then when I get to the plumbing section, pull it out. Yep, that's the right one. Put it back in the pocket. No, that'll lock you up for sure. You might as well just go ahead and surrender.
As a just for
Kim says, I do that. I do that too. No, but that's smart.
I tried with it already.
Okay. It's also State's Exhibit 1, the police report, if you want to just use that.
Did you just use pregnancy test and the screen the same conversation?
just in case.
Boom.
It's more of a
There's the
in
joke.
case thing than a, I'm not worried about it.
I hold up my hands like I'm under threat. Now, as ironic as this is, after I've bought everything, and at Lowe's, my Lowe's, almost every check stand is self-checkout. After I've gone to all the effort of scanning one of the 7 barcodes on each item and found the right one, and usually had to get help unlocking things because I've scanned the wrong barcode so many times. So as I've gone through that fiasco on the financial end, if I'm walking out the door and the alarm goes off, I'm not stopping. I'm like, bring it, touch me, do it. That's me at that point. After I've gone through that checkout and fought with the scanner and everything else, I'm like, bring it. If you think you have the right to do it, bring it. Because if you don't, I will countersuit. I never would, but this is the attitude I'm trying to put off.
Yes.
I dare you to stop me.
I have a chaperone to make sure I got here on time.
I know I scanned everything. I overpaid for most of it.
This is Thurston County District Court trial calendar
Here we
for
go.
Tuesday, 15 July. Here on the matter of the city of Tumwater versus Mark Thomas Snotterly. These proceedings are being live streamed on YouTube, or will be.
They are. We got it, Judge.
Okay, on YouTube to increase public access. Yeah. It's not coming up in the. Okay, now I see it.
Just had to access our channel really quickly. Hey, Judge, welcome. Mr. Snotterly is our defendant. Just waiting for the prosecutor. Maybe the jury as well.
Just kick it, Mr. Weston. Just kick it.
Well, are we currently live at the moment?
What?
Yeah.
Don't.
I hate to admit on YouTube that I failed to plug in the TV. There we go.
TV's
I give the other DPs in the office a hard time that they can't plug in an HDMI cord. Almost done here, Your Honor.
Right.
I have really good spatial awareness and positional memory. And so I can scan things in my cart and leave them all in my cart and know what I've scanned. And so I mentally work through it. I'm like, first of all, you're going to charge me for a bag anyway, so I'm not going to take one. And so I scan things in place, and I know where it's at. And the assistant, what is it? The self-checkout ambassador, whoever that is, will always like come over and like stand like over your shoulder, just like, I'm here watching you. And I'm like, touch me, I dare you. Just, I don't know. I'm doing their job for them. At the checkout. There we go. Oh, we've got a spam call.
City ready to proceed? We are, Your Honor. And Mr. Pastorica?
Yes, Your Honor.
Let's bring the jury in.
Hello? Hello? They hung up. I ran the court feed to their audio and they hung up on me. Waiting for the jury. Mark Thomas Snotterly charged with third-degree theft. What is third degree? We have to look and see what that amount is, because that's usually the degree of theft when it comes to shoplifting has to do with the financial value of the item you attempted to steal. So We can do some homework there. By we, I mean not me. Pregnancy test in the homeowner's special edition section. The unexpected edition. Do you find everything you're looking for? Yeah, and something I wasn't. Yeah, I'm not going to be Lowe's Employee of the Month. I was a big Home Depot fan. I really was. I mean, you can do it. We can help. That was my thing. I loved it. Lowe's, I'm having a hard time loving. Did I say that right? I'm having a hard time loving Lowe's. It's basically the same store, just blue instead of orange.
There are going to be a number of occasions today where you are re-entering the courtroom and everybody is standing. But when you come in, you feel free to just go ahead and have a seat. They're standing out of respect for the role of jurors playing in our judicial system. All right, we are going to start with opening statements this morning. And Mr. Weston.
Thank you, Your Honor.
All right, Mr. Weston. Tell us the facts of the case, or tell the jury. We'll listen in. Ruth, thank you so much.
Good morning to all of you. Thank you for being here. I know there's other places you'd rather be, but I appreciate you being here.
No.
We can't do this without you.
No.
So this is a case about the defendant, Mark Snodderly, walking into a store, the Tumwater Home Depot within Thurston County, putting several items into his cart, walking past all the checkout stands, through the interior doors and almost into the parking lot without paying for the merchandise. You'll hear on testimony later today from the officer and the loss prevention specialist that on October 12, 2023, the defendant arrived at the Tumwater Home Depot. The defendant parked his car, walked into the store, the main entrance, grabbed a cart, walked into the store, walked and made his way to the garden center where he eventually picked up a shovel and some other items. He then made his way from the garden center into the main part of the store, grabbed some other things such as Febreze and Charmin toilet paper, and eventually making his way to pick up a Milwaukee pack out, like those little storage containers where you keep tools and other things like that.
This is murder stuff.
Now,
all of it.
Right after the defendant picked up that Milwaukee pack out, he made his way to the front of the store, bypassing all checkout stands. He walked past self-checkout, he walked past customer service, he proceeded out the front door. Now, you're going to see a little bit later today how the Tumwater Home Depot is set up. And so there's two sets of doors that you have to get through to walk into the parking lot. You'll see, based on testimony, that the defendant walked through the first set of doors, where the carts and everything are, right before you enter the parking lot. That is where Tumwater police officer Rachel Johnson encountered the defendant, also where loss prevention specialist Samuel Hoffman encountered the defendant. As soon as the defendant saw the Tumwater police officer in loss prevention, he stopped right there with his cart and immediately turned around and ran back in the store. At that point, Tumwater police officer stopped the defendant along with loss prevention and was subsequently arrested, and that's why we're here today. Now, this case is about a theft in the third degree. And to do that, you'll hear from the two witnesses who I previously mentioned. Their testimony will be the evidence that you will rely upon. There'll also be a photo of the layout of the store to kind of help you kind of see the movements of the defendant and kind of help you understand what the loss prevention officer was talking about when he moves throughout the store, where the layout of the checkout stands are, where he encountered the defendant, and where the defendant made it before he was encountered, then turned around. Now, after all the evidence is presented, I will stand back up here for my closing argument. And at that time, I will be asking you to find the defendant guilty of theft in the third degree. Thank you.
Hang on. You say he turned around before he was encountered? Like he forgot to check out and went back towards the checkout and you stopped him there?
Members of the jury, good morning.
Not guilty?
We are here today because the prosecution is telling you that my client, Mr. Schneiderly, committed a theft at the Home Depot in Tumwater. He is relying on the testimony of the two witnesses he mentioned, and he is proceeding.
Welcome.
Telling you that there is no other explanation for what happened. However, you will hear evidence that Mr. Schneiderly parked at the Home Depot and walked around the store gathering items. And when he was exiting part of the store and encountered the loss and prevention officer and the police officer, Officer Johnson, he told them that he was going outside to look at the plants. You will hear that he did not ever have the opportunity to leave the store with the items. You will also hear that the exit that he was leaving was nowhere near where his car was parked. You will also see no video or photos of the incident. You will be relying purely on the testimony of these two individuals and what they perceived to be happening. However, you will not we will not be provided with enough context or explanation to know without a reasonable doubt that what they perceived was accurate. There is another explanation, and that explanation is Mr. Schneiderly's. He's not required to testify, but you will still hear what he told the officers and the loss prevention officer. And what he told them was that he was trying to go continue shopping. You will hear that there is no signage or anything telling Mr. Schneiderly that he was not allowed to go outside to look at the items that were for sale outside of the store. You will hear that he was never given the opportunity to pay for the items that he had in his cart. And you will hear that the circumstances surrounding the contact and arrest was one in which he was presumed to be doing what they believed he was doing and not what he told them he was doing. And this is a situation where my client was not given the benefit of the doubt, and the people involved who witnessed him in the store and subsequently arrested him did not consider any other explanation as to his actions or intent. And for those reasons, at the end of this trial, I will be asking you to find him not guilty because the prosecutor does not have the evidence to prove beyond a reasonable doubt that Mr. Schneiderly did steal anything from Home Depot or intended to steal anything from Home Depot. Thank you.
Thank you.
All right. A little rough, but I get the gist of it.
If I may go get him, Your Honor, the state's calling loss prevention specialist Samuel Hoffman.
Now, these loss prevention specialists typically are good at their job, not necessarily good at testifying in court. So I've got nothing against Samuel. I'm just saying, don't expect detective level oration here. They're the beefy eyes and ears of Home Depot. That's what they are. Let's see how this guy fits the profile. Maybe he's like next level. He's like retired SEAL, Navy SEAL, and.
Hoffman, step up here, please.
Judge, are we going to get the camera this time? Sometimes they turn on the witness camera.
Right hand for me. Where the testimony in this case is the truth, whole truth, and nothing but the truth.
Yes. He's a big guy. The judge is looking up.
Remember, if you're being asked questions today, folks to your right, that's the jury. They're the ones who need to hear. Okay. Make sure your voice is heard.
Yes, sir.
I do the same thing.
Can you provide your full name for the record, please?
Samuel Lott Hoffman.
And do you go by Samuel or Sam?
Sam.
Okay. And can you spell the last name for me?
Hoffman.
And what do you do for a living?
I'm the Senior Asset Protection Specialist for Home Depot.
Ambassador.
And how long have you been doing that?
I've worked with Home Depot for the last 4 years and been in asset protection for 3 of those 4.
Okay. And so with your job at Home Depot, what is it your day-to-day job look like?
I'm responsible for internal and external theft investigations within Home Depot. Most of my time is spent on the sales floor looking for external theft.
Now, what store do you usually work at?
I'm the district supervisor, so I travel between all 8 stores in the district.
Okay, and what 8 stores are those?
We have stores in Chehalis, Tumwater, Aberdeen, Olympia, Lacey, Spanaway, Bonnie Lake, and Puyallup.
Okay, and so do you remember what store you were at on October 12th of 2023?
Yes, I was at store 4724, which is the Tumwater store.
And what city is that located in?
Tumwater, Washington.
And what county?
Thurston.
Thank you. And on October 12th, why do you remember that day?
Yes.
And why is that?
There was a theft that occurred that filed a report for with Officer Johnson.
Okay. And kind of starting at the very beginning of that incident, can you kind of briefly describe like how it started?
So patrolling the sales floor, identify a subject enter the building. I recognized the suspect or subject, contacted my partners who were working with me at that time, APS Nicholson and APS Sturdivant. And we got onto a conference call and started observation of the subject.
And is it normal to have that many loss prevention officers working at one time?
We work anywhere between 2 to 4 people in a store at a time, sometimes more, depending on what we're doing.
I can't reveal the inner workings of Home.
Do you guys work together when something like this happens?
Yes.
Give me 1 second, Your Honor. I got to grab a pen real quick. I'm good.
He's not the ambassador. He's the king, president of loss prevention.
So you saw an individual. Do you recognize that individual in the courtroom today?
Yes.
Can you point to the individual?
Right there.
And can you identify a piece of clothing that he's wearing?
Yeah.
I guess describe it.
He's wearing a flannel shirt.
Let the record reflect that the loss prevention officer, Samuel Hoffman, identified the defendant as the individual he encountered on October 12th of 2023. Now, when the individual was in the store, did you observe him place any items in his car?
Yes. He was observed selecting a shovel, some cleaning products, and a Milwaukee Packout, which is a portable toolbox.
And so based on your extensive experience as a loss prevention officer, was there any behaviors you observed that were consistent with someone just browsing or shopping?
Suspect was noted using furtive head and eye movements, continually looking around, trying to see if he was being watched. A lot of times, individuals that commit theft select multiple different brands. Most individuals who are shopping for tools generally stick to the same
brand. So if you're a Milwaukee guy, you stick with Milwaukee. If you're a DeWalt guy, you generally stick with DeWalt.
Because the batteries fit.
And multiple brand and is usually an identifier that we use along with furtive head movements and the way individuals are selecting items. We look for things like rapid selection with no regard for price. Just walk by, grab something, put it in a cart and go.
I'm going to do this next time.
There's other indicators that we look for as well. Body language, how they're moving throughout the store, whether it's rapidly or slowly. Just observations off of normal behavior.
And so is it, based on your experience, is it possible that someone might just know what they want and are rapidly going there and back?
Yes.
Okay.
I still want to do shop just like this.
Was all the behaviors and characteristics you just explained, did you observe any of those on October 12th?
Yes.
Well, what ones in particular?
The furtive head and eye movement, rapid selection of multiple brands of tools and or accessories.
The toilet paper? Is that an accessory? Okay. Grab like the Charmin and the...
Is it fair to say that you're familiar with the layout of the Tumwater store?
Yes.
And why is that?
I've worked with asset protection for 3 years. I've spent countless hours working in that store.
And Your Honor, I would like to show the witness what's been marked as State's Exhibit 2. So I'm showing you what's been marked as State's Exhibit 2. Do you recognize that?
Yes.
And how do you recognize that?
It's a thumb drive that contains a map of the store layout, which I provided to you.
And on that red tag there, what's on the tag?
My initials, the date and time.
And what are your initials?
SLH.
And what is the date on the tag?
7/15/2025.
And what time is that on the tag?
8:33.
Now, what the layout on the flash drive, was it the only thing on that flash drive?
Yes.
And that layout is a fair and accurate representation of the store?
Yes.
And Your Honor, if I may, I'd like to admit and publish the State's Exhibit 2 to the jury.
Mr. Pastor, any objection?
No objection.
Admitted to State's Exhibit number 2.
Give me 1 second here, Your Honor.
I've not been able to find Sam Hoffman on social media, probably because of his covert lifestyle. Having to sort of fly under the radar at Home Depots and not be recognized, because that really thwarts the sting operation, which he's in charge of for 8 stores. Don't want to blow his cover. Yeah, that's why he's testifying off screen to protect his anonymity. I don't know. Mr. Snotterly buys a shovel, wants to go look at plants.
If you have the copy, we can just refer to that. Okay, right? Thank you.
Your Honor, would you like a copy or?
No.
Okay.
So far, I'm not guilty. I mean, you all should be not guilty so far as well.
Now, if you can kind of explain the layout of the store here, where is the front part of the store?
All right, the front part of the store is on the bottom right here.
And the back part?
The front's in the bottom.
Right there.
The back.
And how many entrances are in the store?
We have the lumber entrance / exit right here.
Oh, it's
right off to the side here. We have our main exit, which is by our self-checkout. Couple of fire exits here. Right here, we have our main entrance, which is by our customer service desk. And over here, we have our garden exits, which are in our outdoor garden department.
And so on October 12th, what entrance / exit you observed the suspect go into? Well, enter the store in.
Enter the store, I believe it was through this exit. I would have to refer to my case files to...
My case files.
If I may refresh his recollection with his memory. States Exhibit 1, which I think the still have.
He doesn't remember where the guy came in the store. This is important. Got case files.
Would it help if you reviewed your report or narrative to kind of remember?
Yes, sir.
Sort of did that backwards. He's supposed to say he doesn't remember first. He says, I think I remember it's this one. Probably got it wrong, is my guess. Generally review first, then testify. Oh, I'm sure there's a promotion involved as well. This conviction goes through, it's an extra 10 cents an hour or something. It's
Pages 3 through 7, which are the pictures and his narrative. Pictures of the incident from Home Depot that were filed from Home Depot to law enforcement.
Yes, that is the SCO exit, which is located right here, which is self-checkout.
Okay, and that's where he entered?
Yes, sir.
the SCO, self-checkout. I didn't know they had an abbreviation.
And okay, so once he entered the store, can you kind of lay out to the jury his like kind of the direction that he went based on your observations?
He was seen coming over, selecting a cart, moving down into the outdoor garden department, selected some merchandise, and then moved up to what we call the center racetrack, which is a horizontal aisle that spans the width of the store. Observed coming into aisle right here, which is where our cleaning products are. Selected a couple of cleaning items, placed them in the cart, and then returned and moved his way to aisle 8. Came to the front of aisle 8. In the front, right here on the front of the store, we have a lay down that contains several tool layouts to include Milwaukee tools and pack outs. He was observed selecting a Milwaukee pack out, placing it in the cart, and then was observed moving along the front racetrack towards the main entrance over here.
Okay, and before we go on, if you don't mind flipping that over for me, the police report, and putting it face down is all. Oh, I'm sorry, closing the packet and putting it face down. Thank you. Okay, so picked the Milwaukee pack out and started making his way towards the front. What happened next?
He was observed exiting the store into the through the main entrance while walking out of the store, holding up a receipt, entering the BOPUS vestibule, which is right here on the front of the store, which is where we have our buy online, pick up in store lockers along with our carts.
Mm-hmm.
Once he crossed the threshold right here at the front into that vestibule, I was entering the store through the main entrance. I was outside with Officer Johnson and another officer, while my two partners were on the floor conducting continuing surveillance.
Now, you mentioned you were outside with Officer Johnson. How did you know the suspect was exiting the main entrance?
I was on a conference call with my two partners.
Okay. And
relaying information the entire time they were in the store. He was in the store.
Okay. And so as he was exiting the store, what did one of your partners relay to you?
They relayed to me that he was crossing, bypassing all points of sale and moving into the vestibule without purchasing merchandise.
Is it possible to still enter the vestibule, and then eventually pay for merchandise?
By Home Depot policy, we have the ability to make an approach once an individual crosses and bypasses all points of sale.
Oh.
And looking at this map here, where is that point where he passes all points of sale?
Right here on the front at the very front of the building, before you cross into the vestibule, we have 2 yellow bollards right beside our customer service desk. And once you pass those bollards, you have passed all points of sale.
And that's what happened here?
Yes.
Why didn't you wait for him to exit the store completely? Like walk through this main door and then through the vestibule where the cars are, and then out here and contact him in the parking lot or somewhere around there?
We find it easier to maintain merchandise and or prevent fleeing if we approach a subject in that area.
It's easier to catch them before they get away.
Due to safety concerns.
Traffic.
Now, a couple minutes ago, you mentioned that the suspect was waving a receipt or something similar to that.
The suspect had a receipt in his hand that he held up as he was walking past into the vestibule.
And were you able to see what that receipt was or what he was holding?
Yes. Once we made our approach, I identified myself, as asset protection. And he's like, I've got a receipt. I'm just going out to look at flowers.
Okay. So
the receipt did not match any of the items that were in the cart.
Mm-hmm.
And it was from a different date. I can't recall, the items or the date on the receipt.
Okay. So we kind of, might have been due to my questioning, but we kind of jumped around there for a little bit. So he exited the store. You and Officer Johnson observed him as he walked through that very first exit door. What happened when he saw you and Officer Johnson?
I walked into the vestibule holding up my badge, identifying myself. As soon as I did, he immediately turned around and walked back into the building.
Did he bring the shopping cart with him?
Yes. My partner, Sturdivant and Nicholson, approached from behind and secured the shopping cart.
Now, is it based on your experience as a loss prevention officer or specialist, if someone was just shopping or casually walking around, browsing?
Objection, calls for speculation.
So let's let me hear the full question first.
Based on your experience as a loss prevention officer and the fact that you're in charge of the whole district in this role, and you've been doing it for some time, and this is your day-to-day job, is it normal for customers that are just browsing or shopping to turn around and flee or run when you show them your badge?
No.
I will allow the question.
Now, after he turned around, where did he go?
He walked back into the store and was confronted by my partners who were approaching from behind.
And on this map here, can you kind of point where he was eventually stopped and confronted?
Right in this area right here.
So right before the exit doors?
Yes.
And that's where you looked at the receipt and?
Yes.
Did he provide any other information or of the purchase, like any other receipts or
no
anything of that sort? Was there any reason based on your observations and your in your investigation / encounter to believe that he purchased the merchandise?
No.
Objection, calls for speculation.
Yeah, I'll sustain that.
I believe
the jury should disregard the answer to the question provided.
Apparently, you don't get that head start at Home Depot, at least up in Washington. They'll get you as soon as you pass those yellow bollards.
Now, you mentioned how the defendant or the suspect indicated to you that he was going out front to go look at the flowers or plants or whatever it might have been out there. What month was this when that happened?
This was in October.
And are there generally plants and flowers out on the front?
Sometimes, yes. I can't recall if there were anything sitting outside at that time, but we do have merchandise that is displayed on the front apron of the store.
Are there flowers or plants in the garden center?
Yes.
And Where did the suspect initially go when he first entered the store?
Into the garden center.
Everyone knows the best ones are out front, though.
Nothing further at this time, Your Honor.
Mister.
Good morning, Mr. Hoffman.
Good morning.
I want to start by verifying, and I apologize, do you mind keeping that up?
Yeah.
Can you point with the pointer where Mr. Snarley parked?
I believe he was parked under the canopy right here, but I'm.
And that's the canopy for picking.
For the pro loading zone.
And then you indicated that you contact people in the vestibule or before they get to the parking lot to prevent fleeing. Is that correct? And the exit he left was not near or the same exit from where he parked.
Correct.
Correct. He would have had to walk the length of the store across the parking lot to get to his truck.
Yes.
Okay. But his truck was parked right by the lumber.
I'm mad because he parked in the pro parking. It's a revenge.
You indicated that he was holding a receipt.
Yes.
Did you obtain that receipt from him?
I can't recall, sir.
Okay.
I was not the primary asset protection specialist on that case. I was one of three.
Is it normal procedure for the primary person to obtain something like that and provide it to law enforcement?
Sometimes, depending on if it pertains to, that if it has merchandise that is shopped for on that day.
Okay. And if I could state Exhibit 1, is that still?
If he's waving a receipt, that does seem somewhat deceptive.
You indicated there are items outside of the store for sale.
Yes.
And there are more than just flowers?
Yes.
Tools and things?
Mainly locked up lawnmowers and barbecue.
Lawnmowers.
Okay. But generally outside the garden or in front of the garden center exit, there's also usually plants and things?
Yes.
Okay. Are there any signs at the exit telling customers not to bring carts outside?
Not for sure, sir.
Okay.
The law is more important than the signage.
You indicated that one of the things you look for is someone choosing multiple brands of tools.
Yes.
And is it fair to say that in your experience, people stick with one brand due to the tools being interchangeable with each other?
Yes.
And that's usually due to like batteries and
battery types and other.
And like attachments for the tools?
Yes.
Okay. And you indicated Mr. Snarley took a door, and is it correct?
I believe so.
And a Milwaukee toolbox?
Yes.
Okay. And neither of those are electronic, correct?
No.
Do either of those have parts that are interchangeable?
No.
Okay.
Took a DeWalt and a Milwaukee toolbox. DeWalt is the yellow and black brand. Milwaukee is the red and black brand. They're very different color schemes for products. Both make electronic hand
So lastly, I
tools.
just want to verify, or I guess indicate that he, Mr. Snarley,
Ambassador.
went to the garden center, and then went into the store, correct?
Correct.
And can you point out, I apologize, where he picked up the toolbox?
I believe it was on the front racetrack right in this area.
Okay. And so if he wanted to get to his truck, which was parked here, he could have exited here.
Yes, the cashier stands are located right here.
And if he wanted to go back and look at plants, he would have exited through over here.
Going in this direction.
Thank you.
I love pretty paintbrushes. They're pretty. I've got a few myself right now. Spend a lot of time keeping them clean.
And before he turned to go back inside, he did say that he was going to look at the flowers.
He turned around immediately as soon as I entered the vestibule with the officer.
You heard him say, "I'm going to look at flowers," though?
After I approached him.
Okay, thank you. No further question.
Question?
Can you point to where Mr. Snodderly was parked his vehicle?
I believe it was right here underneath the pro canopy.
And he entered right there by where he parked?
Yes.
And then your testimony is that he went through the store, and then what door did he exit out again?
He exited out through the main entrance, which is by our customer service desk.
Based on your experience with that store and doing what you do for several years, why would someone exit out of the main entrance?
Objection, calls for speculation.
Yeah,
Can you kind of briefly is it possible, based on your knowledge of the store, to exit out of the lumber entrance or the cash check stand entrance there where he entered without passing a register?
No.
And are there any registers near the exit that he went through?
You have 2 return registers that are right here on the side of the customer service desk. And there is an open register right here on the front of the customer service desk as well.
And can you where are all the other registers at?
You have register 1 and 2, which are right here by the lumber doors. And you have a couple of registers that are right here along the front, and our self-checkout registers right here. And then you have the 2 garden registers out here at the garden exits.
So based on what you just said, is it possible to get out of the lumber exit and the garden entrance without going by a register?
You have to bypass a register to exit the store at either of those entrances.
Now, you also mentioned, you mentioned and Mr. Pazderka mentioned how the defendant was going outside to look at flowers. When did he tell you that he was looking at flowers? When he encountered them, or after he went back into the store?
After he turned around and went back into the store after the approach.
And so you identified yourself, he turned around, and that's when he said he was looking at flowers?
Yeah.
And you didn't continue to proceed outside to look for flowers after that?
We approached him right there and identified ourselves, and at that time we were trying to get him to go back to our office to be processed.
And based on your experience as a loss prevention officer, what was the most common exit that someone exits when they are attempting to shoplift?
The main entrance is used very frequently.
Why is that?
There is usually nobody standing in or around the main entrance, and it's just easy walkout.
Nothing further, Your Honor.
Call me detectives. 3rd degree shoplifting means under $750 total value.
Mr. Chairman, you indicated there are 2 checkouts at the garden center?
Yes.
Okay. And so are there checkouts at the lumber exit?
Yes.
Okay. And you said did you hold up a badge when you identified yourself?
Yeah.
Okay. So he saw your badge and heard who you were before he turned around.
Yes, he was.
Okay. After you contacted him, did you ever give him the opportunity or ask him to pay for the items?
No.
No further questions.
Question, anything else?
Nothing further, Your Honor, but I would like to refer this witness possibly later on if needed.
Members of the jury, any questions for Mr. Hoffman?
Jury questions?
Remember, they have to be in writing. Do you have one? Okay. Amy, we'll get your questions, please.
We have questions from the... He hasn't done this before.
If you have questions, you may hand them to Amy.
A lot of times $1,000 is the limit between misdemeanor and felony. So he kept it under that.
Anybody else?
Detective Eds, hit me up on the burner phone. I'd be happy to answer your questions, seriously. Thurston jury questions. These could be good. See if the judge reviews them with counsel. He should. The judge is busy doing some paperwork.
Step back into the deliberation room. I'll discuss the questions with counsel.
The jury has to leave for this one. This is new. I haven't seen this particular judge, take questions before. Oh, the laundry case. Where's the did we miss laundry case? Hang on. Where's Judge Simpson? Judge Cedric Simpson Court.
Asked. Two are the exact same, and one is different. The same is not unexpected based on the testimony, which is, how did you recognize the defendant when he first walked in the store?
You should have objected.
Which gets into the subject matter we had yesterday, the discussion that we were not going to get into the prior incident, to be no indication of the prior incident. So I'm not going to ask that question, but this indicates why we have to be concerned about that. Any comments on that, Mr. Weston?
I mean, he patrols the store. He wanders it on a daily basis. I don't think it's hard to believe that he might recognize just an everyday shopper there compared to someone that might have done something before. Like I was there on Saturday and Sunday. So if he was there, he might have recognized me if I came in on Monday.
Except I think that the testimony was that Mr. Hoffman then arranged for his 2 loss prevention. They immediately started a conference call to follow him. So the implication being that there was something that led them to believe that Mr. Snodley was going to do this. So
that and his observations that he testified to, that looking around, rapid pace, picking certain objects.
Right. Anyway, that's why I made the ruling I did, which is based on the testimony that's been presented, that happened right away. Okay, well, we see this guy. We think he stole before from us. Let's keep an eye on him. And then that's when they track all the other indicia of that he's doing what we think he's doing.
Indicators.
So I don't know any way of allowing that and not getting into a prior event, which
I mean,
already been excluded.
I do think I could introduce a prior event if needed. I mean, defense counsel during opening statement did mention that the defendant did say he was going outside to look at flowers.
Well, that's not testimony. If Mr. Snodley testifies, then I think that opens up a lot of possibilities for you. But so far, he hasn't testified.
Understood.
Okay. All right. So I'm not going to ask those two questions, but we all know those two jurors at least will. That's an issue for them. The question that I am inclined to ask, and I'll hear from counsel, is who witnessed the defendant holding up the receipt? And it seems to be saying if outside with the officer. So the question is, did Mr. Hoffman see Mr. Snodley holding up a receipt, or was it one of the other loss prevention officers who saw that?
My wife just brought me a plate
somebody
full of
else.
Panda
I can answer that real quick, actually, based on my conversations.
Well, no, you don't need to answer it. Do you have any objection to me asking the jurors, asking Mr. Hoffman that question in front of the jury?
No.
Mr. Pester?
No objection.
Okay. So that is the one question I will ask. The other two questions I will not ask. And when they're back from their restroom break, bring them in to do so.
I had no clue she was going to do this. She just brought me a plate full. I have to show you this. I've got the chow mein, beef broccoli, and honey walnut shrimp on here. Oh, it's hot. Complete surprise. My wife is amazing. Well, I knew that, but wow. As far as Judge Simpson goes, just looking through he has not yet had the case with the one lady, that hasn't happened yet. Wow. That shrimp is good. I actually don't like walnut at all, but the honey walnut shrimp has very few walnuts and a lot of shrimp. Oh, that's good. I'm in a happy place. All right. Yes, Virginia, they did recharge Raul Valle with all the reckless stuff, the things that we found out after the fact. The jury foreman spoke out and said that we were hung 11-1 in favor of guilty on the reckless. There was one holdout. That's fascinating.
Please be seated.
Okay, jury's back. Here we go.
Folks, we received 3 questions. 2 of them are the exact same question, and those 2 questions I am not going to ask. Mr. Hoffman, who witnessed Mr. Snodley holding up the receipt if you were outside with the officer?
My 2 partners. And I observed the receipt in his hand when I made the approach.
And let's make sure that the jurors hear all of that. All right, Mr. Weston, anything further from Mr. Hoffman on that question?
No, Your Honor.
Mr. Pesturk, anything further?
No, Your Honor.
You speak according to it. Mr. Hoffman, thank you for your testimony. You may step down. However, you're not to depart. Mr. Weston, which is you to remain. So, okay. Weston, next city witness ratings.
The city calls Tumwater Police Officer Rachel Johnson to the stand.
Johnson.
Yes, Your Honor.
Officer Johnson, if you could state your full name for the record, please.
Rachel Elizabeth Johnson.
And can you spell your last name?
Johnsson.
And what do you do for a living?
I'm a police officer.
Where at?
The Tumwater Police Department.
And how long have you been doing that?
For about 6.5 years.
And what is the training that is required to become a police officer?
You have to complete the basic law enforcement academy at the Criminal Justice Training Commission.
about 720 hours of training. Additionally, you have 3 months of field training, so on-the-job training with 3 different trained officers. And then after completion of that, we have annual training we have to follow up with, and we can go to external department trainings as well to specialize in different things.
And so there's continuous training that you do throughout your career.
Yes.
Now, you've been an officer for how long? You said 6 years?
About 6.5, yes.
And all of that has been with Tumwater?
Yes, I was a reserve officer previously for a little over a year with the Raymond Police Department. And then I was hired by the Washington State Liquor and Commission Board. I went to the academy through them. I was with them for about a year, and then I was picked up by Tumwater Police Department. So I have more than 6.5 total of law enforcement training, but with the Tumwater Police Department, it's 6.5 years.
So within that 6.5 years, how many theft investigations have you led?
Numerous. I couldn't even say. It's multiples a week.
Multiples a week?
Yes.
And how many theft investigations have you been a part of, not just investigating, but helping other officers with?
Multiples a week.
If you could give me and the jury an estimate of how many.
Oh my goodness. I couldn't even give an estimate. It's probably 7+ a week for the last 6.5 years.
And how many of those investigations have happened at the Tumwater Home Depot?
Multiples. It's one of our bigger stores, and Tumwater predominantly is a retail corridor.
And do you remember what you were doing on October 12th of 2023?
I was working routine patrol, which means I answer whatever calls of service is dispatched to us.
And did you get a call that day?
Yes.
And what did you do after you got that call?
I responded to the Home Depot in Tumwater for a call of service of an unwanted person where the business was wanting an individual trespassed.
And what city was the store, was the Home Depot located?
In Tumwater.
And what county?
Thurston.
And the state?
Washington.
Now, when you arrived at the Home Depot, what happened?
When I arrived at Home Depot, I met with my other partner who arrived on scene with us, and I met with Samuel Hoffman outside the store to start filling out the trespass form.
Now, so after you started that whole process, what happened next?
I had reviewed the defendant's DOL photo before making contact, just so I knew exactly who I was serving the trespass form on.
And were you able to identify the defendant that day?
Once I made contact with him, I was able to verify that the DOL photo I reviewed was the same individual that I was contacting.
And can you point to the individual that you contacted that day in the courtroom?
Right there.
And let the record reflect that Officer Johnson has identified the individual at Home Depot as the defendant, Mark Snodderly. Now, after you reviewed the DOL photo and kind of talked with Mr. Hoffman a little bit, what happened after that?
Samuel Hoffman advised that he was listening to his other asset protection employees who had eyes on Mr. Snodderly in the store. He advised me and my partner that Mr. Snodderly was about to exit the main entrance with a cart full of items that he did not pay for.
And what did you do in response to that?
I went to the main entrance that he was about to exit to intercept him from being able to enter the parking lot, therefore creating a smaller distance for him to be able to travel with the product.
And if you can kind of, with the laser pointer, kind of point where you were parked and kind of show the jury the path that you took to the front door.
I'm not as familiar with this layout.
Sorry. The front of the store is right here, lumber entrance.
Okay. I parked my vehicle right here near the lumber exit, and I walked to the main entrance with my partner and Samuel Hoffman.
And so when you walked to the main entrance, what did you observe?
I entered the first set of doors that are available from the outside, which then enters to a vestibule, which then enters a second set of doors to go into the main store. So there's 2 sets of doors you have to enter before entering the main set of doors. So entered the first set of doors from the parking lot. I was in the vestibule area with the carts section. I saw Mr. Snodderly with the cart full of merchandise exit into the vestibule from the main building. Samuel Hoffman identified himself to Mr. Snodderly. Mr. Snodderly made eye contact with myself, my partner, and Samuel Hoffman, and then started backing into the store with the cart.
Now, you've mentioned you've been a part of numerous, countless theft investigations, specifically at the Tumwater Home Depot there. Have you encountered prior suspects in that same location?
Yes.
And based on the countless investigations you've been involved in, is that a pretty common area to encounter the shoplifting suspect?
Yes.
Welcome, Broken Baker and friends. I'm eating my lunch, sorry.
Nothing further at this time, Your Honor.
Mr. Pisturka.
Morning, Officer Johnson.
Good morning.
You indicated you approached the exit to contact Mr. Snodderly. Were you walking with Mr. Hoffman?
Mr. Hoffman and my partner.
Okay. And so you all approached Mr. Snodderly together?
Around the same time.
Okay. And were you dressed as you are now?
I was.
Okay. After you arrested Mr. Snodderly, did you eventually became aware of where his truck was parked?
Yes.
Okay. And that was by the lumber exit?
Yes.
Okay. And that was not the exit where you encountered him?
No.
Okay. When you encountered Mr. Snodderly, you heard him say that he was going to look at the plants?
I don't recall.
You don't recall? I'm going to hand you the marks to state it's Exhibit 1. You recognize that document?
It's a arrest report for the Tumwater Police Department.
And did you write that report?
Yes, sir.
And can you turn to the narrative page? I believe it's page 3 of the actual report. Yes. And in paragraph 2,
objection. Hearsay.
Well, let me get the question first.
If you review paragraph 2, can you does that refresh your recollection as to whether you remember whether Mr. Snodderly said anything?
Yes.
Okay. And so Mr. Snodderly did say that he was going to look at the plants?
He mentions plants, yes.
Okay. And you can flip that back over now. Thank you. When you approached Mr. Hoffman, or I apologize, after you had arrested Mr. Hoffman, did you ever review the receipt that Mr. Hoffman mentioned?
I was not aware of a receipt.
And then you sent Mr. Hoffman back into the store. At any time, did he ever try to abandon the cart?
He provided the cart to a loss prevention employee other than Samuel Hoffman while we contacted him.
And at any point, you never asked if he could pay for the items?
He invoked his rights.
Because you told him he was under arrest?
Yes.
Okay. But after he invoked his rights, or sorry, prior to invoking his rights, you weren't able to ask him if he could pay for the items?
I couldn't because he was at a detention and that would have been an incriminating question.
Okay. So from the time that you began to engage with Mr. Schneiderly to the time that he was under arrest, how much time transpired?
Probably a couple minutes.
Okay. No further questions.
Thank you. Mr. Weston, anything further? Not at this time, Your Honor. All right, thank you. Members of the jury, any questions for Officer Johnson?
I would like to have to reserve this witness for a little bit, Your Honor.
Okay, Officer Johnson, you may step down. Thank you. Weston, any further city witnesses?
Not at this time, but give me 1 second here, Your Honor. There is something I would like to take up outside the presence of the jury.
All right. But at this point, do you have any further city witnesses?
No, Your Honor.
Okay, so at this point, the city is resting.
I might need to recall one of my witnesses depending on what the court says. Like, you know.
Okay, all right. Folks, if you'll step back into the deliberation room. Thank you.
I think he made a boo-boo. I think he left something out. He's looking at the elements and the charges, and he's like, uh-oh, I didn't get this testimony in. So now he's going to ask to go back and call a witness again.
Weston?
Give me 1 second, Your Honor.
This is typical of the type of trial we see in this courtroom, usually 1 or 2 witnesses, usually 0 or 1 witnesses for the defense, usually the defendant, and then a quick verdict. I'm still monitoring Judge Simpson's court. When the laundry lady comes up, we'll have that recorded. We will not miss it. We do call this courtroom the Holiday Inn Express courtroom, also known as the baby lawyer trials, because they're usually entry-level lawyers and prosecutors that handle these cases.
Part of the RCW and the Whitlo for theft is that the defendant or the accused intended to deprive another party of such property, and I believe intent is one of the biggest issues in this case, and so the state would want to introduce prior acts to prove intent, not to choose that he has propensity to commit theft, but to show that he had the intent to commit theft on this day because of the prior incident at Home Depot that I do have a police report for. The facts are very similar, exiting out the same door, things of that sort. It happened with the same loss prevention officer. He's able to testify. He's here currently. That's why I reserved him. Looking at the rules, prove intent, assuming the intent is actually an issue. Apparently inadmissible when intent's not an issue. The fact that he claims he went out the main entrance doors to look for flowers, while on a prior incident he went out those same main entrance doors and back to his vehicle a few months prior.
I guess he's just thinking this over. Maybe the judge is reading the law as well.
Defense would object. The court has already prevented the witnesses from testifying about those prior acts. I believe on the same basis that Mr. Weston is claiming they should now allow testimony to that effect. I would also indicate I have not been provided a copy of that police report they're referring to, and I've not been able to review it.
And it's the state's understanding that we only had a conversation about propensity evidence, not actual other motives or intent, other exceptions under 404B. Additionally, part of plea negotiations involved the case that I'm trying to introduce here as a prior misconduct. So defense counsel was put on notice and should have been aware that this case did exist.
Being aware the case exists is different than.
Oh, okay. I don't need to back and forth there, so just everybody hold on.
Judge is reading the law. We're giving him some quiet time to get it to think this over, but I think he won't mind me talking to you just a little bit. Big shout out to my wife who went to Panda Express, unbeknownst to me, got my favorite food for lunch, put on a plate and brought me even chopsticks to eat it with, which is the only way to eat Panda Express. That makes what makes it really Chinese. I just opened up my fortune cookie, and I'm not sure if this is a good or a bad thing, but there is no paper inside. None on this side. And none on that side. I don't know. Man. I was going to share it with you. But my fortune cookie had no fortune. Wrong answers only. What should my fortune cookie have said on it? That's bad luck. Yes. Make your own fortune. Eating the fortune cookie anyway, even though it's defective. All these things are true so far. You get a refund. That part not true. Don't remodel the bathroom. judge is, to his credit, apparently making the decision from the bench on this one, reviewing the law, and he might be allowing this in because the law allows it. I realize he made a prior ruling to keep it out, but the issue to keep it out might have a little more weight this time because there was a police report in the past, but there were no charges. And if there's no charges and no conviction or a guilty plea, how do you hold that against somebody because you only have an allegation where the truth has not been confirmed? Thank you for what you do and don't do. It's quite unfortunate. I realize there is a police chase happening live. The problem I have with showing it is every single time we show it, I get demonetized, which is a pain in the butt, quite honestly. I work about 21 days a month on average. 20 and a half, if you count yesterday. And it would be like just zoinking 1/20th of your paycheck for the month when that happens. Because it takes everything. It doesn't care. So. We'll see this judge. Just want to make sure he's not just sleeping. He is reading. About ready to make a ruling here. This has taken longer than the entire rest of the case. Mr. Weston wants to add an addendum to his argument. Thinks he's got some better points to argue. That's not how it works. Out of Philadelphia, this little bit of news, possible new court case coming. Police are investigating an attempted robbery of an armed Brinks truck in northwest Philly, city of brotherly love, on Tuesday morning. Attempted robbery of an armed truck. You know firearms were involved. This courtroom has 0 spectators there. There are more people on this side of the screen than on their side. As far as spectators, there's nobody. The defendant has fallen asleep. He's, I think he's just hit REM 3 or something. There have been several armed truck robberies in Philly so far this year. Whoa! So they failed. Alyssa, yes, Raul Valle got charged again. He got charged on all the counts with the lowest lesser included, which is the reckless version of each of the charges. So
Prior incident with
one in July.
Huh?
One in July.
Yeah, there's one in July that's actually currently in jabs as well, but it's a prior incident between the defendant and my loss prevention witness.
Facts of that case.
Facts are that the defendant walked in Home Depot, wandered at the store, took things in
Same store?
Yeah, same store, observed by the same individual, and walked out of the same entrance, that he walked out here, powered through the front door, And my loss prevention officer stopped him in the same exact place that he was stopped here, and he gave up the merchandise. But given the fact that defense counsel is claiming that he didn't have, my interpretation is that he's arguing that his client didn't have the intent to deprive Home Depot of the property because he was merely going out front to go get flowers. I'm trying to introduce this to show that he had the intent to deprive Walmart property, not because he has done it before, but because he did it in the same exact way as he did in that incident as he did here.
Mr. Hoffman, you contacted him on the 6th of July.
Correct. Yeah, sorry, Home Depot, I mean.
And you're indicating it happened in the exact same way, going out the same entrance in the vestibule was contact. So,
correct, Your Honor.
Report. Did Mr. Snodley say anything when contacted by Mr. Hoffman in July?
He said a number of things, Your Honor. I'm not sure. I'm not going to ask Mr. Hoffman to repeat them because it, I would argue, would be a 403 issue. I'm only trying to introduce the fact that he did the same thing on that date as he did here. I mean, if you want me to go in the statements that were made throughout the incident, I will, but I'll defer to the court on that.
And Mr. Snodley was arrested, hence the charge that's pending on that case.
He was not arrested.
He was not. He was he fled from the parking lot, but he was positively identified. And I believe, and this case was referred to our office due to the fact that he left the parking lot, which I would believe is before officers were able to arrive.
But he hasn't been charged.
Briefed by both parties, and the court considered trying to do it on the fly on the court days. Not advantageous to a really considered decision. So, just as a teaching point going forward, you know you have a prior, you're worried about your ability to prove intent, put a motion before the court saying, can I use this or not? And you know. And we are today trying to figure that out.
Understood, Your Honor.
That's learning point number one.
I'll ensure that is fixed in the future.
Okay.
Your Honor,
the appellate courts aren't favorable on this. They create some exceptions, but reading all the case law, they really try to figure out ways to make it just applicable. Pretty rare occasion. So there's a general view that it's, in fact, and I'm sure you've read it in Tagline, it's generally seen by courts as a way around the prohibition against proving propensity. You can try to prove intent by showing prior bad acts. What you're really trying to do is say, hey, look, the guy's a thief. He was a thief those days and he's a thief this day. So that's, Tagline recognizes that courts tend to look at it that way. And so, Mr. Pezderka, your argument as to why in this specific case involving the same loss prevention officer and allegedly Mr. Snodley being contacted in the same way, fleeing, why this case wouldn't fall under the exception for proving intent.
Your Honor, I guess a number of reasons. I would start by pointing out that this court has communicated to myself as well as my colleagues that we
this court doesn't do trial by ambush. And as you noted, this was not brought up or filed as a pretrial motion so that this could actually be litigated. And to that end, I do believe that this is after witnesses, the state has presented its case, realizing that it needs a workaround to prove intent, and trying to shoehorn this in now. So I don't think it's timely. I don't think that this is the procedure that this exception is supposed to be used. Additionally, this is if Mr. Wilson's correct in that they have now filed this case, it is a new charge that Mr. Snarley has not been convicted of. He has the presumption of innocence. The officer is going to be testifying that he was doing the exact same thing when his intent and what actually happened on that day is also in question. There is no, proof that
defense wins this one.
He, outside of his testimony, that he did anything wrong. He's just saying, especially he's just saying that he was doing the exact same thing. It's essentially trying to establish, yes, character rather than intent. And so, yeah, for those reasons, we would object.
Well, Judge.
May respond, Your Honor.
He says, no, you've already talked enough. In the prosecutor's office, the other prosecutors do watch this. They're some of the only viewers online that watch this, and they like to rib each other a little bit. And this prosecutor in pre-trial admitted that he likes to make fun of the other prosecutors who struggle with the HDMI cord or something like that. I'm sure if this guy loses this case because he neglected to get the intent testimony in, he's going to take a little bit of a ribbing himself from the other prosecutors. I mean, it's one thing to catch a guy red-handed shoplifting. It's another thing to try to prosecute him and lose. On a technicality. He's probably already getting texts from some of his buddies. I'm going to shrink my camera down a little bit because the judge is hiding in the corner. Give him a little room to do his reading. He says he's been reviewing case law from the appellate courts, which don't like this because it's a workaround on a prejudicial evidence exclusion. But the law is written that there is a workaround in certain scenarios, and it seems to fit this situation. Now, the argument that the defense was not properly notified or noticed about this evidence is a strong one. The defense was right when he said it's one thing to tell us that about a previous thing, and it's another thing to provide us a copy where you're responsible to give that discovery over. And if they didn't give that over, then I'd say inadmissible. So I'm leaning defense on this one. Not sure what the judge is going to do, but hopefully nothing because the prosecutor just left. See ya, apparently. Barb, the judge muttered a little to himself, and he says, we don't do trial by ambush here. And this is last minute throwing something in that ambushes the defendant. Let's see what the ruling is.
Weston, that you had contacted Mr. Snodderly on the 26th of July, so 3 months earlier.
That's a voir dire.
In a very similar situation.
Judge,
yes, sir.
Judge is asking questions.
Just tell me briefly your memory of that event, 26th of July.
Mr. Snodderly came through the store, selected multiple items, walked out of the main entrance, bypassing all points of sale without purchasing the items. I approached him within the vestibule, identifying myself. At the time of the approach, he secured a axe handle out of the cart and threatened me with physical violence.
Seems a little different.
Was he arrested or?
He fled, ran to the parking lot, got into his vehicle, and fled the scene.
And what's the degree of certainty you have that it was Mr. Snodderly who was that one that you contacted on the 26th?
100%.
And tell me why.
Facial features, the way he was displaying himself, and I also have photographic evidence that I confirmed that I maintain.
Okay. On the date, the 26th of July, had you seen Mr. Snodderly prior to that?
No.
Okay. And when he was walking out of the vestibule, how did you know that this was an issue? What caused you to contact Mr. Snodderly?
In order for us to approach an individual, we have several steps that we have to follow before we can, make a contact for a theft.
Just tell me what happened on the 26th of July. What was it about that day that caused you to contact Mr. Snodderly?
Him bypassing all points of sale with a loaded cart full of merchandise that I
Were you in the store and saw that? And
yes.
So unlike this occasion where you were outside the store talking to other loss prevention officers, on the 26th of July, you were actually in the store and observed.
Correct. And I was working solo that day.
So you followed Mr. Snodderly out the doors and contacted him in the vestibule?
Yes, sir.
He ultimately fled?
Yes, sir.
Well, know how he ID'd him.
Yes.
And the only time we've seen Mr. Snodderly.
I've had another incident with Mr. Snodderly in the Chehalis store. And my partner had an incident with him at the Olympia.
Okay, but just tell me right now, just where you have seen Mr. Snodderly. And the Chehalis store was subsequent to this, or?
It was after, yes.
Okay. Okay, thanks. You can step back. Thank you. It's only okay.
I think he's going to allow it. So judge just did a voir dire, called the witness in, talked to him himself, asked a few questions about the priors, Apparently there were two prior, one that was very similar that ended in with a threat of violence, and allegedly the defendant fleeing the store, getting in his vehicle and leaving. No arrest on that one, but now that there appears to be charges pending on that case, but it has not yet gone to court, even though it happened before this occurrence, right? Or maybe it happened well, it had to have happened before this one because he was recognized for this occurrence. How many stores have you stolen from? You really got to stop doing that. Josh says, I think he'll allow it, and I think the defendant will testify. That will open the door even more. If he allows it, then, of course, the defendant can testify. Because the only concern the defendant had was opening the door to this. If it's allowed in without him testifying.
It's definitely at issue in this case. It does appear to me to be based on cross-examinations. Identity, it's not an identity issue, it's an intent issue. That is, was Mr. Snotterly intending to walk out without paying for these items, or was it mere inadvertence, or was he actually going to look at something outside and coming back in and paying for the items? So the intent to deprive is going to be a central issue for the jury to have to decide in this case. For the reasons I stated earlier, counsel need to look at their cases and see where these issues are and put them before the court, so you can have an idea coming to a trial what the trial's going to look like. Don't like it when this happens. There's nothing in the rule that says you have to do that, though. It's just better lawyering. That's why you do it, and you get better decision making. I'm going to allow the state to inquire Mr. Hoffman. He had a prior contact, and I don't need all the facts. I just need that he suspected that Mr. Snotterly, based on his observations, had walked out of the same store without paying for items. He contacted him to discuss that issue with Mr. Snotterly, and Mr. Snotterly fled. That's really all the facts I need to have for you to argue that this had previously occurred with Mr. Snotterly, and the contact then in October wasn't an accident. It was similar to what was displayed in July. So I will allow that for that purpose.
Yeah, there's a 404B 4-step analysis. I just want to ensure we kind of go through that.
Yes.
Your Honor, if I could just clarify the scope of the testimony and request that Mr. Hoffman be advised to not speak to what he references the axe handle and being threatened, as that's not.
Yeah, that's not relevant here. I don't want that. I think that will significantly taint the jury.
Understood. I wasn't going to go that far. It was just going to be that he observed him in the store, place items in his cart or whatever he saw him past the checkouts or point in sales, entered the vestibule, and that's where he contacted Mr. Snotterly.
My request was to advise Mr. Hoffman. I understand that you're not going to.
Yes.
No objection to that.
I would also direct you to advise him. Right. He's not to mention the alleged assault.
Understood. I also think a limiting instruction is necessary as well.
Yeah. Expect you to prepare it.
Understood. And I'll have that done before jury instructions.
Yeah, you'll get that. Well, we're going to be at jury instructions this morning, so.
Oh, it's working on it right now, Your Honor.
All right, and for purposes of 404B, this is obviously prejudicial testimony. It's attempted with pretrial ruling to exclude it before we began testimony, but it's been clear from the testimony that intent is going to be the main issue in this case. And with the information provided by Mr. Hoffman today that indeed he was the one who contacted Mr. Snotterly in July in the exact same place and the the exact store and the exact place. I do think that under the intent exception or the even though it's prejudicial, probative value outweighs the prejudice to Mr. Snodley. So for that purpose, I will allow that limited inquiry of Mr. Hoffman about that prior event. So let's bring the jury back in. Have your brief inquiry of Mr. Hoffman, subject to cross-examination. And have you provided Mr. Pesdurk a police report from that incident?
I have not, Your Honor. I believe prior counsel.
Yeah.
Give me 1 second here, Your Honor.
Amy.
Hold the jury. This is an appellate issue. I think the judge knows it.
Find it from a previous communication.
Did you just provide it to him?
No, it was previously we provided back in March or made aware to him in March.
And you may be seated. All right, folks, the city is going to recall Mr. Hoffman, Mr. Weston.
Thank you, Your Honor.
Mr. Hoffman has not been talked to yet. Mr. Weston still is trying to transfer the police report over to the defense. They're about to bring into court. He hasn't done that yet. Now he runs out to grab the witness, and that time has to tell him, don't say the part about the axe handle and the fleeing the scene. Yeah, now's the time to take a plea deal if it's still on the table. Because this is not going to end well. No one's buying the flower story now after they hear this other thing, this other testimony.
And the state's recalling loss prevention officer Samuel Hoffman to the stand.
Stop at the red next seat. I'll remind you you're still under oath.
Yes, sir.
Mr. Weston.
Man, these pauses are terrible.
Mr. Hoffman, do you remember where you were July 26, 2022?
Yes.
Where?
I was working as an asset protection specialist for the Tumwater Home Depot.
Let's clarify the date. Would you check the year?
And
check the year.
Oh. Sorry. Do you remember where you were July 26th of 2023?
2023, yes.
Where was that?
Tumwater Home Depot.
And why do you remember that day?
I approached Mr. Snowderly that day for a theft that occurred.
And why did you approach him?
Mr. Snowderly was observed selecting multiple high theft items throughout the store, to include a DeWalt jumper box and some other tools and cleaning supplies, and was observed exiting the store through the main entrance. bypassing all points of sale with no attempt or mention of purchasing the items in the shopping cart that he had. And I approached Mr. Snowderly in the vestibule where the carts are located, identifying myself as Home Depot Asset Protection, and let him know that the stop was for the theft that had just occurred.
And did he go back in the store? Did he, what?
Mr. Snowderly refused to comply and fled.
With the merchandise?
No. I was able to maintain control of the merchandise.
No, you kind of won't unpack everything you kind of said there. He went out the main entrance.
Main entrance, sir.
And where is that in the store?
That is in the front of the store on the, towards the western side of the building. By customer service desk.
And you observed him place the items in the cart?
Yes.
You observed him place and pass all points of sale?
Yes, sir.
And you contacted him in the vestibule?
Yes, sir.
Nothing further, Your Honor.
And
Mr. Hoffman, on that date, Mr. Schneiderly did not leave with any of the items, correct?
I was able to secure the shopping cart in the vestibule.
Okay. And you did not ask if he could pay for them?
There was not an opportunity given to ask. Mr. Snowderly fled on approach.
Okay. When you say fled, he returned to his car?
Yes.
Okay. No further question.
Wes, anything else?
No, Your Honor.
Thank you. Thank you.
Prosecution rests.
And at this time, the city does rest. Mr. Paz-Turca.
Your Honor, the defense rests.
All right. Thank you. Folks, when we hear both parties have rested, that means there will be no further presentation of testimony. What we're going to do now is once again send you back into the deliberation room, and we are going to discuss proposed jury instructions. Our alternate juror will still remain with the jury.
So I guess it's time to do a poll.
Proposed jury instructions worked out. We'll bring you back in here. I will instruct you on the law, and you then hear closing arguments from counsel. So if you'll step back there, we'll come get you. Yes. Based on this?
Yeah, based on the question.
I'm not going to allow that. I appreciate that you have the question. I'm sorry that we're not going to be able to get to that because that was a recall of a witness, and we only apply that during a case. Thank you.
Okay, so this question is pretty simple. Did Mr. Snodderly try to shoplift from Home Depot? And this question only applies to the charged incident, okay?
I did just receive an email with the additional proposed limiting instruction.
Okay, polls up. Did Mr. Snodderly try to shoplift from Home Depot? This is the charged incident only. Options are no, I believe the flower story. No, he forgot to pay. Or, yes, he's a klepto.
And do you have any objection to the proposed limiting instructions, Mr.?
No, Your Honor.
All right, the instructions will be as follows. Number one is the 3-page opening instruction. Number 2 is the reasonable doubt instruction.
And Your Honor, I apologize. I don't know if I've ever provided a copy.
Yeah, I can give you.
Once again, prosecution neglects to give something to the defense that they're supposed to give to them. There you go. You can have my copy. There you go.
Instructions. We'll make copies for counsel. Order them.
Okay. Sorry.
So the instruction that's been emailed to you. Just that instruction.
They're just going over the instructions right now.
No, WIPIC, like citation, just delete the bottom of it, just X.
The laws are a little bit different in each state. You don't necessarily have to make it out of the store.
Use real quick to let one of my witnesses know he's good to go.
You don't necessarily have to make it free and clear. You know, taste that fresh air before you can be called shoplifting. That, as they say in Home Depot here in Washington, they call them bollards. They're those big yellow poles that people hit with their cars sometimes. This is RA. That are on the inside of the store by the doors on the exit. If you make it past that, basically through that first set of doors into the man trap, as some people might call it that, busted. Past all points of sale. Part of me wants to, you know, it's the naughty part of me, but part of me wants to go shop and try to just get asset protection ambassadors' attention, just to see if I can spot them. You know, I want to spot the undercover guys that are in the store. Obviously, the cameras are everywhere.
That instruction. 3, direct or circumstantial.
Wouldn't dream of stealing it.
Number 4 is the to convict instruction.
And I wouldn't be like sticking stuff in my pockets or anything.
Number 5.
I'd just be putting stuff in the cart.
Definition of theft. Instruction number 6. It's wrongfully means gain wrongfully with property. Instruction number 7. Property means anything of value. Instruction number 8. Definition of intent. Instruction number 9 is the limiting instruction on subsequent testimony heard on the intent. Instruction number 10.
Live stream the whole thing.
Not being required to testify.
It's terrible.
Instruction number 11 is the duty of the jurors. And instruction number 12 is the closing instruction. The verdict form appears appropriate.
I turn sideways and I just disappear. Purple.
Weston, any objection to those court's instructions?
No.
Pastor, any objection?
No.
Your Honor, real quick, are we doing closing after lunch or before?
Not even 11 yet.
All right. Just asking as well.
We're doing it now, he says. It's not even 11. RA is 6'2". Ask him if you can zoom on the racetrack past all points of sale. No warning sign. They don't need to have one.
It is open.
So, and Mr. Pastor, I'd like your input on this. The first sentence, I'd like to amend it, where it says certain evidence has been admitted in this case. says for only a limited purpose, and I want to define that purpose so the jury knows exactly what it's to be used for. I think what it should say is certain evidence has been admitted in this case for only the limited purpose of proving intent. Any objection, Mr. Pester, adding that line?
No objection.
And if you'll amend the instruction that way.
Give me 1 second here.
Actually,
I believe it was just directly from the
your second
Whitlo.
sentence makes that clear.
Yeah.
Okay, no, that's okay. We're good then.
Yeah, that was directly copy and pasted from the Whitlo again.
Okay. Yeah, we're good. Okay. Council need copies of the instructions as I've just numbered them.
Yes, please.
Okay, so and
How tall is Mrs. R.A.? Shorter than me. Oh, it's tying those running shoes. And he gone. He gone. Might not come back. He verbally sort of gave the prosecutor dressing down, but then sided with him and gave him everything he was looking for. We've got third degree. Theft in the third degree is a gross misdemeanor. In Washington, that penalty means it could be, let's see, third degree, up to 364 days in jail, $5,000 fine, restitution payment to the store victim for damages, and some other conditions could be imposed as well. Just pulling a Farag. Yeah, the defendant, I could just barely overhear him. He said, I'm going to just go smell the flowers real quick. And he stepped out just briefly. It's ready for the verdict music. We haven't even had closings yet. I want verdict music. You guys, we got cheated out of verdict music yesterday. If I pick something up from outside to buy, am I stealing it because I am past the point of sale? No, unless you take it out to your car. And arguably, this would be the most stealable item at the store, right? It's something particularly like the plants that are just free outside right near the parking lot. They'd be the easiest to just grab and go. There are cameras. All these stores have cameras. But their value is actually really low. There's some good profit on selling those plants. I know this because I used to work in a greenhouse. Plants are good money. They're really cheap. I mean, dirt is cheap, water is cheap, and they sort of grow on their own. The Girl Scout cookies on the table outside are free, says Greeners. No, they're not. Don't steal from the Girl Scouts, Greeners. Where's the poll? Poll's at the top of the chat window. If you click on it. The question is, did Mr. Snodderly try to shoplift from Home Depot? Charged incident only. No, I believe the flower story, 14%. Another 6% say no, he just forgot, 7% say no, he just forgot to pay And a whopping 80% are saying, yes, he's a klepto, meaning kleptomaniac, somebody who steals habitually or something similar to that. So we're going to end the poll with that, with about now only 79% firmly believing in his guilt. Oh, back up to 80. There we go. The results are in. Spent $30 for a glow-in-the-dark petunia this year. That sounds like engineered. Do they grow that way naturally? I'm in Atlanta, saw my boy win the home run derby. Oh, nice. Nice. I want to say yes just because he has snot in his name. They can get you for shoplifting if you snack on the box of crackers you're planning on buying while still shopping. So, Pamela, here's what I say you do. You use the scan and shop and scan. What do they call that? At Sam's Club, you can go and use your phone to ring everything up as you put it in the cart and just swipe to pay, and it'll charge your card that they have on file. And then you just walk out and you never even see a cashier. They'll just scan your barcode on your phone as you leave. So maybe do that. Swipe and pay for it, and then eat it in the store. Sam's the only store I know that does that. There are a few stores that are trying that out. Some of them have carts that have the mechanism that can tell what's inside. I think it's the same technology that Circle K gas stations, convenience stores use. That you just take whatever items, like all your items, armload of items, you just set it down on the little platform, and it knows what everything is. And it just, here's your total, and then you grab them all and go. It's really cool. Grapes are open season for passerbyers. I think about stuff like this because I'd get fired from my insurance industry job even with a shoplifting arrest. Yep. I had a top secret SCI clearance, and just an arrest would put an end to that for sure. Are we on jury watch? Slumming in Florida? Not quite yet. We're waiting for the defendant to come back, who stepped outside, I guess, to smell the flowers. We're also waiting for the prosecutor to come back, who was telling one of the witnesses that he can go home now. We don't need him anymore. Both the prosecution and defense have rested, and the judge said we're doing closings before lunch. So, Wally World has a scan in store and pay. Kim, it's the best at a gas station. Never stand in line at a gas station again. The Circle K, it's okay. The only other place I've seen this is at libraries. Libraries have switched to have like a little transponder in the back of a book. So instead of a barcode they scan, you just go and you get all the books you want and you just plop them all down, and it's like it knows what your books are. And it's like, okay, done. Scan your card and you're done. I've seen people put an empty candy wrapper on the conveyor for the checker to scan. He's like, I don't want this. Gooey chocolate everywhere. Josh making it up the list. He's now at 4. That's awesome. Walmart Plus, you can scan with your phone. In practice, you also get free delivery with Walmart Plus, so most people do that. Yeah, so you free delivery, or you can do your own work at the checkout, in the store. My Sam's Club, maybe I'll see if I can take a picture of it next time I'm there. My Sam's Club has like a finish line, like a high-tech finish line with cameras. It's got like those trusses, like those little bar trusses, like you'd expect to see at a concert or something like that. It's got those and cameras all over it. And you push your cart through, and it like scans your cart from every angle, and it just sees everything. And then I guess it matches up whatever it sees with your receipt to see if there's a problem. Josh, thank you, my friend. Gifted 5 memberships. Appreciate you, Josh. You were, I happen to know you did that just to go up on the list, but we'll take it. We'll take it. I'm glad I live in a township of 900 people. No one steals anything, merchant or private. I think you could now do the same thing at Home Depot. Sam's has that too. Good stuff, good stuff. So is it stealing if you pick up a broken piece of plant from the ground and take it home? You know it'd only go in the garbage. Debbie, here's a thought. Do you know what propagation is? I think that's the right word. Where you can take a cutting from a plant and put it in dirt and it will grow another plant, like roots will sprout from it. Sometime head down to your local Home Depot in the garden center and look for African violets. And flip over the little tag and look on the back of the African violets. These are like the purple and yellow, beautiful flowers, like velvety flowers. And look at the warning on the back that tells you that if you cut one leaf off a flower and plant it, they're going to prosecute you because the plant is like copyright and that's theft or something. It's bizarre. It's wild. I could not believe it when I saw it first. Josh says I always gift memberships. Haha, but yes, I did it selfishly this time. Sam's gets mad if you have 2 orders in 1 cart. Greeners, I can't click on that. Thank you. It's copyrighted. Yep. I think it's only if you propagate to sell it. Well, that part is in fine print. I only saw that it was illegal to do that. Let's see. Oh, he's back. He's back. I think he went outside and had a little fresh air. I really think the mistake in this trial was from the defense lawyer who should have objected when the guy said, I recognize you. The judge said, wouldn't that be a problem? It would be a problem if you know, he said a jury would imply that it was a negative inference. There would be a negative inference if the jury heard that the loss prevention guy recognized somebody. And that testimony came out and defense did not object. And that developed into how did you recognize him? And you recognize him from this prior incident. And now it's full blown. And now this dude Snutterly is just counting his minutes before he's in custody and serving time because of this. Trauma Llama. Every time I say you can't click on Greener's, you're like scrolling to see what Greener's comment was, right? I should delete it first and then say that. So if taking a violet leaf is like cutting the tag off your mattress? Yes, pretty much. No. It's like cutting the tag off someone else's mattress. That's where the crime is. You can cut your own tag off your own mattress. As long as you don't then try to sell it. Let's see. I am mostly just impressed that I've not entered food coma yet. That food was delicious. It was really good. I really wish this case out of Colorado with the dentist, the killer dentist, would have allowed video. It probably would have been too spicy for our channel at times. Like we might have to like just mute everything and cut to a nice
Amy, did you send those
SpongeBob scene or something.
Yeah. Can I get a copy?
But Unmasked to True Crime on Twitter did a cool breakdown of that case. There's a side chick. There's poison. It's wild. Here's a tweet she gave 23 minutes ago. Colorado killer dentist trial. In the defense's opening statements, they claimed that James Craig had numerous affairs throughout the entirety of their 23-year marriage and that his wife, Angela, was aware of them. She wanted to stay in the marriage because of their beliefs and their 6 kids. Defense implied that James's lover, Karen Kane, was just another woman in the long line of lovers and nothing special, definitely not special enough to be a motive to kill his wife. She described the couple's relationship as complicated and difficult, but loving. Angela was aware of their financial struggles and contributed to the debt herself, referred to Angela as manipulative and broken. She referred to James asking people to tamper with evidence as not a great thing, and he did, and tells the jury to consider credibility when listening to the fellow inmate who claims he tried to hire him to kill the lead detective. This is right up there with Corey Richens. It's like a male version of Corey Richens. It's wild. Anyway, Unmasked True Crime on Twitter. If you want to follow that, she's got some a great breakdown of that. Verdict music, please. We haven't had closings yet. I'm sure we're going to get verdict music today, as long as they remember to show us the live stream. Sometimes this court forgets to let us watch the verdict. Mr. Fix-It, let me just explain. Mrs. R.A. went to Panda Express and bought everything and then put it on a plate for me. She did not make any of that. That was Panda Express on a plate. Marianne, great to see you back in green with that orange courthouse. Wonderful. Is there a jailhouse letter named Drill the Patient or Numb the Dog? No, but there are plenty of internet searches on a secret computer of how to make, was it arsenic? It's cyanide, how to buy oleander, just, there's a bunch of stuff there. Josh says, I'm not going to comment. Apparently, the more you give and the more you talk, the lower in rankings you get. I don't know how it calculates. I wish I knew how it would calculate the top people. It might be like every minute.
Question, you have hard copies of your schematic for the store?
Yes. I've hard copy
for the jurors?
I was just going to give them the flash drive, since that's usually what I was told the court does. At least that's what's happened in the last couple trials and every other trial that I'm aware of.
And
there's nothing else on the flash drive, just the store layout. But I do have a hard copy, at least one, and I know defense counsel and his client
what's your
have
expectation as to how they would display the flash drive in the deliberation room?
Well, it's my understanding that they usually plug it in the TV. At least that's what clerks have told me they do. Now, whether they do or not, I'm not sure. I've never been back there, but the clerk and other members of the court have said that they usually plug it in the TV and kind of go about it that way. But I do have 3 hard copies if needed. Thank you.
This chair is going to break and I'm going to fall off it eventually. It's getting more and more wobbly. Got a Crown and Hogue Laws chat, but not even seen it in this chat. It's specific to each channel, that's for sure. Stacy and Colin moved to North Carolina 2 years ago from Kentucky. Miss having a Panda Express. We have one. I'm in North Carolina, in Greenville. Got one in Greenville. It's actually the new one down by the Honda shop, downtown Greenville. And by Honda shop, I mean Honda dealership, not like the Honda store. It's because you're supposed to be standing. I'm resting my feet on the standing mat. So technically, I am.
Along with the
Granted. And you can clip it. You can clip it and post it.
So the only exhibit going to the jury room will be the hard copy of the schematic.
Are you in?
Correct.
In Jacksonville? Where are you at, Stacy and Colin? I'm trying to think an hour away. Goldsboro, Jacksonville. I guess the beach as well. It could be east as well. I know our little town, Greenville, just is that beeping Mrs. Ari's oven? No, that's the squeaking of the chairs. It's about to fall off. The beeping is people going in and out of my door. We've got a home security system that alerts us to which doors are opened when. 5 minutes from Burlington. All right. You guys should have a Panda Express. We just lost our Great Harvest Bread Company. Now the closest one is in, I believe, Jacksonville. Great Harvest Bread is, they should change it to be Great Price Bread because it's extremely expensive. Like the price is great.
Folks, I'm now going to instruct you on the law that you're to apply in deciding the case. You now have the law in your hands, and you make copies and place it on your seats. You will, as I said at the beginning of the trial, have that with you in the deliberation room for your deliberation. So you're welcome to just sit there and listen as I read them, or you can read along with me as I do. It's up to you entirely. It is your duty to decide the facts in this case based on the evidence presented to you during trial. It is also your duty to accept the law from these instructions, regardless of what you personally believe the law is or what you think it ought to be. You must apply the law from these instructions to the facts that you decide have been proved and decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during deliberations consists of the testimony that you have heard from the witnesses, any stipulations, there have been none, and the one exhibit that has been admitted during trial. If evidence was not admitted or stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the clerk and given a number, but they do not go with you to the jury room during deliberations unless they have been admitted into evidence. The one exhibit that has been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that has been admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not the party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately,
the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest the witness might have in the outcome or the issues, any bias or prejudice the witness may have shown, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The attorney's remarks, statements, and arguments are intended to help you understand the evidence and to apply the law. It is important, however, for you to remember that the attorney's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in these instructions to you. You must disregard any remark, statement, or argument by counsel that is not supported by the evidence or by the law as stated in these instructions. You may have heard objections made by counsel during trial. Each party has the right to object to questions asked by another attorney and may in fact have a duty to do so. These objections should not influence you. Do not make any assumption or draw any conclusion based on an attorney's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you are to disregard that entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the attorneys may properly discuss specific instructions. During deliberations, you must consider the instructions as a whole. As jurors, you are officers of the court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged. The city is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. A defendant is presumed innocent. This presumption continues throughout the entire trial, unless during deliberations you find that it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. If such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, we're satisfied beyond a reasonable doubt. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in the case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. To convict the defendant of the crime of theft in the third degree, each of the following three elements of the crime must be proved beyond a reasonable doubt. 1, that on or about October 12th, 2023, the defendant wrongfully obtained or exerted unauthorized control over property or services of another. 2, that the defendant intended to deprive the other person of the property or services. And 3, that this act occurred in the city of Tumwater, Thurston County, Washington.
I have the
If
laundry
you find
lady
from the
ready to go.
evidence or from
I
the
got it.
elements 1, 2, and 3 that they have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any of the elements, 1, 2, or 3, then it will be your duty to return a verdict of not guilty. Theft means to wrongfully obtain or exert unauthorized control over the property or services of another, or the value thereof, with intent to deprive that person of such property or services. Wrongfully obtain means to take wrongfully the property or services of another. Property means anything of value. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result, which constitutes a crime. Certain evidence has been admitted in this case for only a limited purpose. This evidence consists of testimony regarding prior contact between a witness and the defendant and may be considered by you only for the purpose of determining intent. You may not consider it for any other purpose. Any discussion of the evidence during deliberations must be consistent with this limitation. The defendant is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case yourself, but only after you consider the evidence impartially with your fellow jurors. During deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of returning a verdict. When you begin deliberations, you should first select one of you to act as presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 of you are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If, during deliberations, you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During deliberations, you may discuss any notes that you've taken during the trial if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You'll need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during deliberations. If, after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you've been unable to answer, write the question out simply and clearly. And you can just do that on one of your notepad papers. In your question, do not state how the jury has voted. The presiding juror should sign and date the question. Give it to Amy. I will confer with counsel to determine what response, if any, can be given. You will be provided the exhibit that has been admitted into evidence, these instructions, and verdict form for recording your verdict. Some exhibits and visual aids may have been used in the courtroom, but will not go with you to the jury room. The exhibit that has been admitted in the evidence will be available to you in the jury room. You must fill in the blank provided in the verdict form, the words "not guilty" or the word "guilty," according to the decision that you reach. Because this is a criminal case, all 6 of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form, and by Amy, you will then be conducted into court to declare your verdict. Hi, folks. You'll now hear closing argument from the City of Tumwater first, Mr. Weston.
There's closings. Mr. Weston will take his time to start. I do have the laundry lady ready to go as soon as they go off to deliberations. Oh, you just barely moved that the other way.
This is a simple case. This is about the defendant walking into the Tumwater Home Depot, grabbing a cart, putting things in the cart, and trying to leave the store, walking past all the check stands, all the point of sales, trying to leave the store, but luckily was unfortunately stopped by loss prevention and the Tumwater police officer. Now, it's as simple as that. Put the property in the cart, tried to leave without paying, and that's that. Now, there's a number of jury instructions, so if you want to flip to jury instruction number 5 for me, or you can listen to me, but I found that it's generally easier to just kind of follow along. So jury instruction number 5 is the meaning of theft, and we're going to kind of break this down after this, but theft means to wrongfully obtain or exert unauthorized control over the property or services of another, or the value thereof, with intent to deprive that person of such property or service. So meaning of theft, what exactly do I have to prove regarding theft? So if we want to kind of go back one page to jury instruction 4, these are all the elements that I must prove beyond a reasonable doubt for you to return a verdict of guilty. Now, there's 3 of them, and we're going to kind of break these down. So we're going to kind of go to number 3, that this act occurred in the city of Tumwater, Thurston County, Washington. There's no dispute that this happened in Tumwater, the county of Thurston, and in the state of Washington. You heard from the loss prevention officer and the police officer. They both worked in Tumwater. Loss prevention worked at the Tumwater store, which is in Tumwater within Thurston County and Washington. Tumwater police officer works in Tumwater, patrols Tumwater, which is in Thurston County and the state of Washington. It seemed very basic in some of the questions I asked. That was kind of why I was asking those questions, to establish this element. Now, the only elements that we are really going to focus on are elements 1 and 2 of that same instruction. So element 1 is that on or about October 12th, 2023, the defendant wrongfully obtained or exerted unauthorized control over the property or services of another. Now, there's a few things that I have to do in that element just by itself, is that I have to show that this happened on October 12th, 2023. You heard from both witnesses that it did happen on October 12th, 2023. Now, this might not be apparently clear, but another thing I have to show is that the defendant is the person that was encountered by law enforcement and loss prevention. You heard the loss prevention officer identify the defendant as the person he encountered on October 12th. You also heard the police officer testify that she identified the defendant as Mark Snodderly via DOL photo that matched the database, and so he is identified that way. Now, I also need to show as part of element 1 that he wrongfully obtained or exerted unauthorized control over property or services of another.
79%
now, we're going to
guilty.
kind of flip back and forth here, unfortunately. But jury instruction 6, you don't need to flip to it. It's only a sentence long. It says wrongfully obtained means to take wrongfully the property or services of another. Now, the testimony of both witnesses showed that he was stopped by the testimony of the loss prevention officer showed that he put stuff in his cart. He made no attempt to go to a check stand. self-checkout, anything of that sort. Went to the front of the store, walked through the front of the store towards the entrance, and walked right out the entrance without trying to check out or even make an attempt to go find a register. You heard that the loss prevention officer stopped the defendant right in that vestibule, right past all the points of checkout, outside the very first doors, in that area where all the carts are, right before as you're about to exit the store. You heard the loss prevention officer testify that it's a store policy that they try to stop people that are shoplifting in that area because it prevents them from being able to flee because there's only 2 exits, rather than waiting till they enter the parking lot, trying to stop them there, and they can go anywhere and loss prevention might not be able to stop them. Now, I kind of want to go to element number 2 here, that the defendant intended to deprive the other person of property or services. In this situation, the other person is a Home Depot. Now, to prove intent, I'm going to flip over here to jury instruction number 8, which you can flip to, you don't have to, totally up to you. That a person acts with intent or intentionality when acting with the objective or purpose to accomplish a result which constituted a crime. And the state submits to you that the defendant here went to Home Depot on October 12th and intended to deprive Home Depot of their property. And how do we know that exactly? So we saw loss prevention's observations. Defendant walked in the store. He was showing indications that he might be shoplifting, looking around over his shoulder, eyes wandering, just to each item rapidly. No browsing, no looking at different things. Went to the garden center, went inside to the cleaning aisle, went to aisle 8, I believe he said, and went to the front and then walked right out. No delay or no hesitation in what the defendant was doing within Home Depot. He went in and then he went out with the merchandise. Now, as I've kind of previously mentioned this with the prior element, he made no attempts to go to a check stand or self-checkout. If he would have tried to check out or do something of that sort, or even made an attempt to kind of, I'll swerve my cart towards a checkout, might be a little more difficult to prove that he didn't intend to deprive Home Depot of property. However, the fact that he made no effort or attempt to go to a check stand shows that he intended to deprive Home Depot, because he went in, grabbed the merchandise, walked out, no stopping other than the merchandise that he needed at that time.
Like the toilet paper.
Another thing to consider is that as soon as he walked out with the merchandise, he ran into the Tumwater police officer and loss prevention. As soon as that happened, he stopped, turned around, and fled back into the store. The defense wants you to believe that the defendant was going out to go look for flowers, that this was just a normal occurrence, that he was going out to look for flowers. Who knows what he was going to do with those flowers? But I want you to consider whether that is reasonable based on everything that you've heard today. Remember during jury selection where I kind of talked about, sure, something's possible, everyone kind of considered things that were possible, but then a number of jurors mentioned how is it reasonable to think that is what's going on based on everything that you've heard. And so what's reasonable here is that the defendant could have looked at flowers if that's what he was going to do before he walked into the store. He parked his car, walked right in the store without looking at flowers whatsoever. Could have looked at them in the front. The very first stop that he went to was the garden center, where loss prevention said that there are flowers year round. He had ample time to browse the flowers if that's what he wanted to do. However, he went to the garden center, grabbed a shovel, left nearly right after that. No mention of flowers out there, and went back into the store. Only when loss prevention and the police officer ran into them in the vestibule and he turned around and was eventually stopped is when the defendant was like, I was only going outside to go look at the flowers. Now, you also heard that from the loss prevention officer, he came back up here to testify for the second time. And that testimony included an incident from July 26th of 2023. You may only use that testimony that you heard to show that the defendant intended to deprive Home Depot of the property on October 12th. So you can't use anything other than the fact that, other than the intent to show that he might have done something. Just because he did something then doesn't mean that he did something now, later. You can only use it to show that you can only use the incident on July 26th to show that he had the intent to deprive Home Depot on October 12th of 2023. On that incident that the loss prevention testified to on July 26th was that defendant walked in, grabbed a cart, just like this case, walked into the store, tossed some items in the car, which loss prevention was able to observe, walked right out the front door, and was eventually stopped by the same loss prevention officer that stopped him on the incident we're here for today. Walked out the same door, main entrance, made no efforts to pay for merchandise, no efforts to go to a self-checkout, check stand, walked right out the front door and into the arms of the loss prevention officer, and the defendant ultimately fled in that situation. Now, the state submits to you that it has met its burden, that we've proved each and every element of the crime of theft in the third degree beyond a reasonable doubt. And because the state submits that we have reached that burden, the state asks that you do your duty and find the defendant guilty of theft in the third degree. Thank you.
Thank you. Weston, you have 5 minutes left in your time. Mr. Pezderka.
Let's hear what defense does here. They put on no defense.
Again, good morning, members of the jury. The prosecution in this case wants you to believe that there is no other reasonable explanation to what happened on October 12th, 2023.
Might get an objection
that
here.
There is no other reasonable explanation that would lead to you to doubt what he has said has been proven beyond a reasonable doubt today. However, the prosecution is asking you to ignore the circumstances and context that have been provided and or that have not been provided that would lead to the conclusion that there is no other reasonable explanation. And so I want to kind of walk through those circumstances and context. We know that Mr. Schnarley parked near the lumber exit at one end of the store. He proceeded to get a cart at the main entrance and go to the garden center where he got a shovel. He then went to the cleaning supplies and got some items before proceeding to the tool section where he got a toolbox. At that point, he ended up backtracking towards the main exit away from where his car was parked at the lumber exit. It is there that he ended up in contact with the loss prevention employee, Mr. Hoffman, and Police Officer Johnson. We know from Mr. Hoffman's testimony that there are no signs telling customers that they're not allowed to leave the store with a cart. We know that there are items for sale outside of the entrance and exit doors. There are mowers, there are plants, there are flowers. Mr. Hoffman, as well as the prosecution in this case, have made use of the phrase past all points of sale. They say that to prove to you that that's what Mr. Schneiderly intended to do is not use a point of sale. However, there's also no evidence that there are signs indicating that customers are not allowed to go past the point of sale to continue shopping. Mr. Hoffman testified that there were 2 checkout areas in the garden center. Mr. Schneiderly could have gotten to those checkout counters easily from outside from where the plants are. Instead, he was confronted by them And the prosecution has argued that it is not reasonable that he fled back into the store. And I think in what is reasonable is to assume that if you were being confronted by a police officer and someone holding a badge, and you did not intend to take items from the store without paying for them, that you would go back into the store to show them that you were not fleeing, that you were not trying to get away with something, that you would stay by the cart and interact with them. We know that Mr. Schneiderly did go back into the store, did stay by the cart, and did tell them that he was intending to look at the plants outside. We also know that Mr. Hoffman nor Officer Johnson never asked Mr. Schneiderly whether he could pay for the items, nor was he ever given the opportunity to do so. Instead, he was arrested within minutes of them contacting him. And the prosecution has mentioned the previous incident that Mr. Hoffman had with Mr. Schneiderly. And they want you to use this as proof that he intended to do something based off of that incident. Mr. Schneiderly did not leave with any items on the July 26th date, and Mr. Hoffman did not ask him to pay for those items on the July 26th date either.
And he wasn't arrested. He has to be careful not to open the door.
I put it to you, the prosecution has not met their burden to prove beyond a reasonable doubt that Mr. Schneiderly did intend to steal those items. Based off of what we do know, but also based off of what we don't know and have not heard. We know that there were 2 other employees involved in this incident that had contact with Mr. Hoffman, and we did not hear from them. We did not see any video or photographs of the incident. There is context and circumstances that you have not seen that allow what you have seen and heard to provide a reasonable doubt as to the prosecution's explanation. Mr. Schneiderly said he was going to look at the plants. Based off of what we know, his direction in the store, he walked away from where his car was parked, directly near an exit. And the prosecution has stated that it's not reasonable that he would return to the garden center to look at plants because he was just there and gotten a shovel. I put it to you that it would be reasonable, and I believe many people have been in a store and realized you've forgotten something and need to backtrack to somewhere you've already been to look at something that you forgot.
Every time. That's how I
Mr. Schneiderly was shopping, and when he backtracked in the store, the law enforcement officers decided that meant he was stealing when he tried to exit to look at the plants. They chose not to believe him when he told them what he was doing. They chose to assume he was stealing without giving him the opportunity to pay for the items. The prosecution is asking you to find that it is not reasonable that he was doing what he said he was doing, that because of where he exited and what he had in his cart, that he was intending to take those items without paying for them. The prosecution is asking you to assume what the officers and the law enforcement officers assumed without meeting the burden of providing you that there was no other reasonable explanation as to what he was doing based off of the information they have testified to.
Yeah, that part's bad. Looks bad. But the cop said she didn't hear anything about that. There was no receipt collected.
I would argue that the prosecution has not met their burden, and I would ask you to return a verdict of not guilty.
And do it quickly before lunch. That's your closing line. Why are you still standing? Just say thank you and go sit down.
Just close by reiterating the prosecution bears the burden of providing all the evidence to show that there are no reasonable doubts to what happened. And I believe that what evidence and testimony has been presented does show a reasonable explanation that would cause a reasonable doubt to what Mr. Schneiderly intended to do. Thank you.
Thank you, Mr. Westbrook.
5 minutes. Back to Mr. Weston.
I just want to kind of address a few things that Mr. Pazderka mentioned. He brought up how his client parked near the lumber door, walked in through the lumber door entrance/exit, then proceeded to grabbed the car, then proceeded to the garden center. You heard the loss prevention officer mention how that entire side of the store, there's self-checkouts, there's several registers. You can't go through that area and out to the parking lot without passing a check stand or a point of sale. You heard the loss prevention officer mention how, based on his experience doing what he's doing, a lot of people that shoplift walk out that main door where the defendant was encountered on October 12th. The reasoning for that is, yes, there is, I believe, was one check stand, but it's always unmanned. There's
Objection. Facts, not evidence.
No. Sustained objection.
Sustained.
Loss prevention officer, that a lot of people go there because he has a lot of encounters with people that shoplift in that area, and that most of them go and exit out that vestibule, and he encounters them in that vestibule. Defense also talks about how there's no signs that say you can't bring your cart full of merchandise out to the front of the store or bring it here or there. Now, part of the jury instructions, I believe it was jury instruction number 3, talks about how you can use your common sense and experience in determining whether that is reasonable, whether you can bring a whole cart of items out through the front of the store and into the parking lot to go do whatever you want to do. You don't need a sign to know that you shouldn't be bringing unpaid merchandise into the parking lot. Another thing that defense counsel mentions how there's only testimony. There's no footage, that there was 2 other loss prevention officers that were helping out on this day of incident. And would it have been nice to have video footage, pictures, numerous witnesses? Yes, I will admit that would have been nice. And that no matter what, you will always wish that there was more evidence, no matter how much the state provides. But the state submits to you that the witness testimony today with loss prevention officer Samuel Hoffman and the police officer is more than sufficient for the state to meet its burden beyond a reasonable doubt. That testimony included that it happened in Tumwater, Thurston County, Washington, on October 12th, 2023, and that it showed that the defendant wrongfully obtained property of Home Depot, and that he intended to deprive them of such property. Now, another thing to mention is that defense counsel brought up that the defendant didn't have a chance to pay for the property today, or on October 12th, that they didn't give him a chance to go back into the store and pay for the property or whatnot. And that he compared it to the July 26th incident where his client never actually had the property. He left without the property. And both of those instances show the intent. He entered the store with the intention to deprive Home Depot of the merchandise. He left the store and stopped by the same loss prevention officer. Both instances, he fled from the officer, one time in the store, one time in the parking lot. It's irrelevant whether he had the property or had an opportunity to pay. He went past all points of sale, tried to go out the front door, into the vestibule, then out into the parking lot. But for loss prevention officer Samuel Hoffman and police officer Johnson stopping them, he would have ended up with the property. So once again, the state submits that it has proven its meeting its burden beyond a reasonable doubt, and that it's your duty to find the defendant guilty. Thank you.
Has meeting its burden? Red Pen, did you just hear that crime?
Hi, folks.
You did.
It's almost noon. I'm going to give you a choice. I can send you back right now to begin deliberations if all of you agree to do so. If somebody's hungry and would rather have lunch first, then I'm going to let you go to lunch and come back and begin deliberations. So, and I'm leaning towards that second option because I think better decisions are made when people are properly fueled. So that, unless you want to try to persuade me otherwise, that's what we're going to do. Is I'll have you come back at 1 o'clock deliberations. Okay, I think that's what we'll do. We will remain in recess. So what's going to happen is we'll send you all out for an hour, see if you take a walk or get something to eat. Come back, and as soon as 6 of you are here, you begin deliberations. And juror number 7, you'll need to come back to make sure that the other 6 have come back. If for some reason they haven't, somebody decides that lunch is more important than deliberations, then we can put you to work. But we'll see the rest of you at 1 o'clock, and as soon as you're all here, then you begin deliberations. When you've reached a verdict, you just notify me. He will be in. All right, folks, it'll be lunch hour, and I'll just remind you, just like I did yesterday, no discussing the case. Now you know everything about this case, but even among yourselves, no discussing the case until you're back in the deliberation room, please. Thank you.
All right. So I'm starting a timer so we know when the hour is up. Bring the laundry lady. Let's see. Let me find where laundry lady is. That's not it.
Any issues from council before we recess? No. Okay. If you're not going to be in the building once the jury started deliberations, just let Amy know how she can get in touch with you quickly so that you can get back here. I don't want to keep them waiting any longer than necessary once they have a verdict. And Mr. Snodley, if you'll remain in the general area so that we can find you when there's a verdict.
Okay, hang on. Need to rewind a little bit. Okay, I think this is it. Let's jump to this. Ready?
I said it that way.
Okay.
So,
Thank you, Your Honor.
all right.
Okay,
Thanks,
thank
folks.
you.
Is this the right laundry lady?
Anderson versus Armani Lyman.
There she is. Here we go. Told you we wouldn't miss it.
Bueno.
She's like, last time I was on the defense table.
State your names, please.
You're gonna be over.
State your name. All right. I reviewed everything in the file, and just to try to resolve the matter if we can. Set it for a final settlement conference today to see if there's a resolution. Ms. Lyman,
Yes.
you still wish to reside in the property?
Yes, last court date, she asked me to stay and I decided that I was.
Pardon?
Last court date, she talked to me after court, asked me to stay, so I decided that I will stay.
Okay. And Ms. Anderson, where are you on this case?
I want to apologize for talking.
Pardon?
I want to apologize to you for over talking over.
It happens. All right.
I just hesitate because I I'm worried about the condition of the property. From the outside, there's already damage, and Ms. Lyman has approximately $20,000 worth of damage on a prior property on Maplehurst, Mr. Fink told me about. So, I mean, I have a $500,000 property and I'm worried about it coming down with Ms. Lyman, since she has a prior history of damaging property.
$500,000 property?
Go ahead, this one.
Honestly, I feel like the little Fink situation on June 27th, he had contacted her.
I don't know what that means.
So I feel like that's a conflict of interest, and we're here for 42 we're not Maplehurst. So I don't see that's being brought up, and for that was a small situation.
Hold on a second. I don't know anything about that. So that's not under my head. Let me ask you this. Has rent been paid and everything, or?
No, I have not.
Go ahead.
She said she would put the $3,300 in escrow.
All right. Is that what you would do, ma'am?
Yes, I did say that, but our last court date, you said that $25 a day was excessive. I ended up paying that $25 a day last month, so I was asking if I could pay
$25 a day?
Yes, so I was asking, could I pay $3,000?
Well, there's gonna have to be a claim on that, but what's the monthly rent?
$3,000.
All right. So I won't give a discount on that. We'll figure it out, but you've agreed to put that into escrow, the $3,300? Run it to place $3,300 in escrow.
She has a question.
And that's really for the month of July, correct? And then $3,300 per month thereafter. All right. Folks, just in terms of resolving, go ahead.
What I was about to say, because last month I ended up paying the $25 a day, so I ended up paying.
I hear you. You're about to repeat yourself. I will resolve that once we get to the end of everything.
Oh.
If it is indeed illegal, but I'll figure it out.
Everyone's raising their
hands. Yes, ma'am.
Last time you said that I could get $100 for late fees for.
I'm not going to deal with late fees, folks. All right now. I'm just not. I mean, the issue is that if there's going to be an agreement that she'll stay, because you filed a termination case, we have to figure out what the terms of that will be. Yes.
I really don't want her to stay because I'm worried about damages to the property.
Okay, so didn't we just go through this?
Yep.
You guys had a conversation about her stay, right? There then becomes this issue regarding damages at other places. I don't know anything about that. You're worried about damages at the premises. So what I was going to suggest to the parties is this. Would you object, because actually I can order it in any event, but that she's permitted to do an inspection of the premises.
There's no damages to the property.
Okay. Yes.
From the outside, there are already 3 damages. There's oil stains in the driveway. There's blinds, and the blinds in the back have been damaged. The screen in the back has been damaged. So that's just what I can see on the outside damages, and that's probably.
Okay, does anybody listen to me? Because it would seem to me that the way to resolve this issue would be for you to be permitted to do an inspection of the premises. Yes.
Also, she would need to change the locks back because I didn't authorize her to change the locks.
Yes. Who's raising their hand next?
What does that have to do with anything right now? Yeah.
I don't want to offend you.
What?
I'm trying not to offend you, so I don't want to.
I'm not easily offended, so go ahead.
I if she wanted to work something out, I would have to be able to talk to her and not the older woman. I mean, there has to be some communication between me and her and not me and this older woman. And she would have to abide by the terms of the lease. That's all I'm asking, sir. I would work things out.
Yes.
She keeps talking about an older woman when.
Okay, so first of all, stop, both of you. I don't know, we come so close and then you guys just start talking past each other about stuff that may in the end not mean a thing. So the first thing is, if her tenancy is going to be maintained, you got to get the 3,300 in escrow. You want to do an inspection of the premises. What date are you going to do the inspection? What date would you like to do the inspection?
This week.
All right, would you be available to let her in to do the inspection this week?
No, I have school and work for the rest of the week. Mandatory school.
I have mandatory schooling.
Could we try for like next week?
Monday, next week. What's wrong with that day?
What time?
In the afternoon, Monday would work. I was just asking a question.
What's the question?
Did you ask her to change the locks back?
No, she's gonna be there. I'm not gonna deal with that right now. Okay? What I'm gonna do is there's gonna be an inspection on the premises.
This is not done. We are not.
So there'll be an inspection on the premises on the 21st. 2025 at, will 2 p.m. work for you? Yes? 2 p.m. All right. Then I need you guys back on, I'm going to move this to, when's my hotspots block on the first?
3 p.m. Your Honor.
So then I want to see you guys August 1st,
August 1st.
2025 at 3 p.m. That'll be an in-person hearing. Come back, we'll look at what the inspection is and how we can go forth with this tenancy.
If the rent is in escrow, how do I pay the mortgage with the rent in escrow?
Well, it's going to be in escrow. I'm not clear, ma'am. It's going to be placed in escrow at this point in time, and then we'll figure out what we do on the 1st. Okay? Anything else from either side? I'm almost afraid to ask.
Just
yes.
Can I be able to call her on her phone and talk to her?
I don't know. Are you capable?
Yes.
Okay. Will that work for you?
Yes.
And you'll answer? Okay.
Wow.
That's resolved.
Fix the issue right there.
Anything else? Great. We'll see you on the 1st. Thanks, folks.
Can you have her change the locks? No. But can you have her change the locks back? No. Just one more thing. Can you have her change the locks?
Okay, let me see counsel on Burnson back, please.
Yeah, he's going to be.
Huh?
Yes, Your Honor.
You don't want to see?
Yes, Your Honor. Where's Your Honor? Wait, let me get my bag.
Wait.
Okay, so there he goes. That's what we missed. That was the laundry lady, the laundry landlord. Josh says he said something happened yesterday. Let's see what we got. We are currently in a holding pattern for Thurston, Washington, where we are waiting for the court to come back. They have an hour, and I'm by my timer They're 12 minutes into the hour, 13 minutes into the hour. So, sorry, you only get, this is the headless shot because I am in fact standing at my standing desk. Good crap, just got the quote from the AC guy. It's not a good quote. He clearly doesn't want to come back. Warm up the verdict music. That's not it, but that was the warm up. It's ready. It says pirate on his shirt. It does. Pirates. This is a fishing shirt. It's not actually cut. It doesn't have tears in it. It has a vented back. It's like a mesh back to stay cool in the weather. Kelly H, thank you for gifting the super sticker, fist bump as well. I think we need to take a break until court comes back, and I will be back with Court Watch out of Thurston County, Washington. They are currently eating some lunch for about 45 more minutes, so we'll be back when they come back, and I expect a very quick verdict in this one. And I'm just going to throw it out there. I think he's guilty. I think he's guilty, and I think they know it. The whole idea, but there wasn't a sign on the door saying we couldn't take your stuff from the store without paying for it. That's not a good defense. So, promises. So we get a Home Depot break. Everyone run to Home Depot. Film it. See if you can get the loss prevention manager to, to follow you around the store a little bit, and then buy everything you want or put it back. One of the two things. Do not steal from Home Depot or Lowe's or anywhere else or Walmart. Just don't steal, people. Don't steal. We're about to get dumped again. No. We've got a case in Verdict Watch. Just about. Well, it'll start in 45 minutes. So, all right. There we go. Is the parking plot not property of the store? According to Home Depot policy, at least in Washington, they can stop you as soon as you pass the first set of doors. So, no, you don't get a head start halfway to your car. If you make it to your car, you get away free. That's not the policy anymore. And if Jim down at the jail in your last stint told you that was the way it was, he is wrong. If you build a portal, you'd be back. There it is. So you don't have to step in the parking lot to get arrested. You don't. As a matter of fact, the next time you step in the parking lot, it will be in cuffs. Likely. Never living that down. Right. I've been ghosted more than past relationships. All right. Maybe today, maybe no. Give me 45 minutes. 45 minutes. We'll be back. What time is it? It's 3:15. We'll be back at 4. It's the end of the day. I realize it's the end of the day, but we're going to watch and stick around for this verdict. It's going to be quick. An hour tops. I give them an hour to get it done. It's going to happen. All right. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe. We'll go live again in 45 minutes today. This day. We'll be back live again today. We'll see you afterwards. Have a good one. Bye.